at bank norms. Mr. Goswami, I'll pass the order. There is a long list. After this, I'll pass the order.
No, only one, you know, annexer 16, my lord. There they have admitted that.
Where? Page?
16 to 16 is by the DFO.
Page.
No, let it be taken off. Let it be done all. And otherwise, my lord, it will get only.
Oh, we'll take it up as the first item. No problem. We'll take it up as the first item. You be here. We'll take it up after the mention. We'll take it up.
Madam.
Yes. Yes. Yes, Mr. Sharma.
Part 4.
Huh.
Can it be taken up on Thursday?
Why?
Some homework is required.
Huh?
Some homework is required.
No homework is required. I've done my homework.
Obliged.
I've done my homework. You place your case. Why? Now tell me what is left here. It was a holiday for 2 years. That period is already over. We will make an observation that will not be taken against you. That much only we can do in this case.
I'm also not.
We are not adjourning at matter. Why did you not give me a list? I have come.
And on 16, Lordship.
When the matter is called up, make a prayer. When the matter is called up, make a prayer. You have submitted. Mr. H. Borua, Learned Counsel for the petitioner. For the Standing Council, Finance and Taxation Department, prays that the matter be not taken up, inasmuch as the arguing counsel, Mr. B. Chaudhary, is not present in the court on account of certain personal difficulty. Also, prayer is not objected to by the Learned Counsel for the petitioners. Also,
an interim order with them.
In view of the above, the registry to list these matters again after 4 weeks on a date to be fixed by it. Interim order, if any, to continue till the next date of listing. 32 to 36. Huh?
I beg to mention a matter for listing, Lordship. It's a different.
Listing cannot be before me. You will have to go before the senior.
Actually, there's a notification by Justice Devashish. It says this, Lordship, our chamber's matter will not be taken. So it's not by me. Highly obliged.
Next week.
Lordship, tomorrow, Lordship. There's an urgency in the matter, Lordship.
What is the motion?
Motion, yes, Lordship. Good sum of money is involved, Lordship.
Motion, I think you have to make an application before the registry. Make an application. If it comes, I'll take it up.
Highly obliged.
Yeah, please, Your Lordship. Item number 53 of the daily list has become infructuous.
Yes.
The matter has become infructuous.
Mr.
N. Gogoi appearing on behalf of A. Sarania.
A. Sarania or M. Sarania?
A. Sarania.
A. Sarania. Mr. M. Gogoi, Learned Counsel. N. Gogoi, Learned Counsel for the petitioner. A Learned Counsel appearing appearing under instructions of Mr. A. Sarania submits that the order violation of which has been alleged in the present petition has during the pendency of the present petition being complied with by the respondent authorities. So accordingly, he submits that the contempt petition be closed. Also, in view of the submissions of the Learned Counsel for the petitioner, the present contempt petition stands closed. Notices issued stand recalled. This is that earth cutting premium for that. Yes. Why? A prayer is made on behalf of Mr. K.K. Mount, Learned Senior Counsel, for an accommodation in the matter today on account of personal inconvenience. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, the registry to list these matters again after 3 weeks on a date to be fixed by it.
But actually, no. No. Only no.
Mr. Saraf is there, or Goel is there.
Yeah.
Why keep this matter pending?
There is a
It's misdeclaration or the other way around. Whether he has been given a notice or not. That much
Yes.
only.
yes, that much only.
You have made your pleadings,
Yes,
very
sir.
elaborate pleadings. No response to that.
Only after 2 weeks, my lord.
Mr. 2 weeks. You're not there. A Goel is there. You had argued the matter. You had taken the interim order. Thereafter, you are missing.
I'm not.
Yes, you have taken the interim order. You have argued the matter.
So we are the, whoever comes daily wages.
Daily wages. Miss A. Gain, CGC, appearing for the respondent submits that she be granted 2 weeks time to make to prepare the 2 weeks. But Miss A. Gain, learning counsel for the respondent submits that the matter be adjourned today on account of certain personal inconvenience faced by her. Also, prayer is not objected to by the learned counsel for the petitioners. Accordingly, registry to list those matters again after 3 weeks on a date to be fixed by.
Already
Yes.
mention was made before, Lordship, about the motion. My
Huh,
lord. In
huh.
fact, we cannot mention the matter.
I know,
before.
but whether it is possible for me to read that,
It's to mention before Lordship only. We cannot mention anywhere else.
then you give it, we will look
The
into.
Lordship may just type because it will automatically listed, Lord.
DDI too.
And my lord, in one of the matters, the B. Chaudhary has taken time,
Huh,
but their affidavit no opposition has not been filed. So Lordship may direct at least them to the. file the affidavit.
32 to 36 or other line log idea. In the meanwhile, the respondent authorities shall invariably bring on record their stand by way of filing an affidavit on or before the next date of listing.
I'm obliged.
Consent of other side, I beg to mention, I
60?
type of daily list.
65. Why?
Regarding this matter, on opposite side, filed a affidavit in opposition in repeat. Filed affidavit in reply.
They filed an affidavit in opposition where? In the writ petition.
Petition.
Your name?
A. Sharma.
Mr. A. Sharma, learned counsel for the petitioner, submits that an affidavit, writ petition or likhi affidavit has been filed on behalf of the respondents in the matter, and accordingly, he desires to bring on record a rejoinder thereto on behalf of the petitioner. Full stop. It is prayed that the matter be taken up after 2 weeks on a date to be fixed by.
A fixed said that.
No fixed date. After 2 weeks. Full stop. Prayer accepted. A registry to list this matter again after 2 weeks along with IA bracketed C number 1850/2025 after 2 weeks on a date to be fixed by.
Interim order may.
Interim order, if any, to continue till the next date of listing. 1850/2025 and 1861/2025. Yes, Mr. Doctor. Mr. Doctor Learned CGC is present on behalf of the AK Doctor Learned CGC is present on behalf of the respondents.
May I please, your lordship, I beg to mention item number.
Respond number 1 and 2.
I beg to mention item number 56. Lordship may allow to complete the dusty service and file the affidavit.
What is the special urgency here to make this mention during the mention hours? Can't it wait till the matter is called up?
Lordship, this matter has come up tomorrow, Lordship, as item number 13. We would like to place the written argument before.
What is the name?
Aroma India Private Limited.
Mr. Saraf had argued.
Yes, Your Lordship. Highly obliged.
Item 1.
Yes, Mr. Goswami. What is that you wanted to point out?
Two documents that I had annexed, my lord, at page 49 in the item 1, my lord.
Hmm.
No, item 2, my 6138. Kindly wait a minute. Page 49. Your lordship has come to that, my lord. There's a letter from the range forest officer who informs the DFO that the lessee and the pata holder did agreement during 1st April so and so as per record. So it is there. And also in the next para. But the lessee could not extract any quantity of river silt following repeated obstruction and assault by the local village. These two. Then again in DFO's letter at page 58, my lord. Page 58. About the middle, my lord, starting in that second paragraph.
58,
Yes, my lord.
this petition completes,
Last page, my lord.
okay, huh.
It may be mentioned, Haji Lord. It may be mentioned here that the present lessee have developed a private road by executing an agreement with the owner of Pataland of Horapara village to use the road which was permitted by you. You means, my lord, he had written to the chief conservator of forest on a query from the government, my lord, which exercise was never completed, my lord. No order was passed on, it had come from the government actually, my lord, Annexure 15. The letter from the undersecretary preceding dated 29 April, man. With reference to subject, I am directed to send here a prayer petition along with the enclosures received from D. Prasad Das and request you kindly to furnish a detailed report along with your specific view. So this DFO's last letter, man, 7916 is with reference amongst other with to this also, man. Annexure 15. It is mentioned in the reference. This letter is mentioned. So there he states this.
Okay. Okay.
But
Anything, Mr. Bhattakur?
well, I have not given him a copy. One, your lordship had brought one citation, man.
Yeah, give it to me.
That is on the read court's power to allow compensation, man.
But Mr. Bhattakur, this is not the normal run-of-the-mill cases we get for mining lease not being performed, the lessee not discharging it. This is a case wherein the lessee satisfied all requirements. And he is only a lessee. The property is yours. You have not been able to permit the lessee to extract. And there is no material here that the lessee on his own had not extracted. Your also contention is that he could not. Now, if that be so, it is your failure.
They sought for renewal also, my lord.
You did not give that
If it-
also.
The conditions were not at all feasible, my lord. Why?
So that you mean to say that renewal was not given because the area was not, it was not open for mining there. So you admit that the exercise that you had carried out was of utility. So why should he suffer? Give him back the amount is with you. We are quashing the Bakijai proceedings. Give him back the amount with interest at bank norms. That much only.
Are squarely covered.
Rules, how can a rules be put to his prejudice? Because he was ever ready to do the extracting. You were not. You with the mighty state, with the power, you could not remove the encroachers from there. Why? That is not an option because he has immediately asked for recalibration of the whole period. And then he came up before this court and the matter is sub judice.
Their position.
Whose position?
Their position.
Show me. Show me.
These two, both the petitioners had assumed possession of the mine.
How? That possession is only in paper.
Paper possession. In the
It's
range
a
office.
paper possession. It's never a physical possession, Mr. Bhattakur.
Happened in range office.
Operational problems they face, my lord, that risk is assumed.
No,
Which will-
I'm sorry. It's not assumed. Because you yourself had gone up there and you lifted your hands.
Forest department gave its full assistance.
Now, if
Whatever
it is not the forest department, where will he go? It's you. He's your agent. You are the principal.
burden to carry out the operation lies on the permittee.
How can he carry out when you yourself is not in possession of
The
the,
environment
prop-
was not there, man.
when you are yourself not in possession of that mahal? It's your possession that will be transferred to him, right? In paper, fine, but in reality, practicality from the materials on record, you did not have a possession of that mahal.
Was never in dispute. All they are saying is that they materials are
Because
obtained.
if that possession is not there, then why did you not facilitate him to take the materials out?
Assistance, my lord. We
What
went to the
assistance?
Police station.
You did nothing. You just issued what you call that FIRs, lodged FIRs, and then started writing letters. Other than that, you did nothing.
Raid operation was also.
That did not turn out to anything. That was a futility because that again the people chased you from there.
The burden of operation is on the.
I'm sorry, not accepted.
My lord, even my lord, seeking to hand it over to us, my lord, your lordship will kindly come to annexure 2, man. This problem was there, man. They actually misled the tenderers.
I know that.
They misled tenderers. This was happening there. That was the existing situation. In spite of that,
Have
they-
you settled that
Advisors-
mahal after that?
Because the stay order is operating.
Page 28, annexure 2, man. Dated 5/2/2014, man.
Forest department is also at loss. It's not that only the.
I know that. I know that. But once you have invited somebody in your bid, you categorically state that this is the mahal, this is the area, this is the quantity. If the person goes there and he cannot extract, not for any fault on his part, because you could not make the mahal free, it was your duty. Or is it that there is a mahal somewhere, you just sit in your office, issue an advertisement, people come. In your office, you sign a document, give it to him, possession. But the mahal, people cannot even enter. He cannot even enter the mahal. Forget the extraction, he cannot even enter the
The
mahal.
forest officials could not enter it.
Enter. There is somewhere I found even ladies had come out
My lord.
in protest.
But my lord, that is the.
That was very nicely
With
put
a lot
in
of malls, my lord.
the.
It is unfortunate that.
That is very nicely put in the report.
Yes.
That is the situation.
Then you will have to, Mr.
That is why-
Bhattakur, you will have to take, you are the state, you will have to take appropriate action. Yes, what do you want to show me?
So, my lord, page 28, annexure 2.
Page 20.
8 to 8 of the Prasad Das. Before seeking to hand over possession, my lord, they were writing to the deputy commissioner, my lord. Your lordship. The subject itself is illegal collection of ordinary clay in the permit area of Boruapara, Thakuriapara, Rajapara. So they knew, they were aware about this. This was going on. And they informed the deputy commissioner illegal mining of ordinary clay in the above mentioned permit area causing heavy loss to of government revenue. Therefore, you were requested to kindly look into the matter and take stern action against the person. And thereafter, they received the money from me. The next letter, 28/2/2014. Why did they receive this money, knowing fully well that they cannot hand over the mining area to me?
So this is the amount you paid.
Yes, madam.
This is the amount and the road. Construction.
And the road. This is the amount and the road. This comes to about 4 lakhs and something, but I have mentioned something.
4 lakh in 2014.
So in the other case, my lord, that is more, my lord. In Jointa Kulkar's case, in Jointa Kulkar, this is 8,85,000. 8/6 of the petition. And annexure 2. Second read petition.
How far is the two mahals, distance between the two mahals?
They are,
Nearby.
I think, contiguous one after the other.
Contiguous. Okay. Anything more?
All men.
Heard Mr. I'll just go through the written argument submitted by Mr. Botago. I got
Yes,
to
sir.
leave. We'll pass the orders. Heard Mr. BD, first of the matter today was listed for delivery of orders. However, the Learned Council for the parties prayed that they be permitted to make further submissions. Full stop. Accordingly, the submissions made by the Learned Council for the parties were heard. Also, the Learned Council for the parties have also brought on record their respective written arguments, which is taken on, brought on record, so and so today. Also, in view of the above position, the registry to list this matter again on Undina Khali is 26 on 26/8/2025 for delivery of orders. Eto by slip koi diba muk agote di diba 22 tarik mane di dile.
I am placing just one citation on the power to grant compensation, my lord.
This
If necessary, and the paras are 27, 28. 27, 28. What the- Only if it's necessary. And also 30, para 30.
okay.
From 27 onwards, man. Okay, 27. Much obliged, man.
Have you gone through the latest 2022 decision of the Supreme Court
20
2022?
regarding my
Not maintainability with regard to the issue that you have raised. We'll come to the 227 thing later. Let's go to the merit. Your only case before this court is that there being an agreement between the petitioner and you, and there being an arbitration clause. This prevents the petitioner from taking recourse to the provisions of the MSME Act, right? That's your case. This specific issue was examined by the Supreme Court in the case of two 2022 SSC Online SC 1492. 92. So in that view of the matter, the approach made by the petitioner before the MSME tribunal cannot be faulted. One. Two, this is a petition under 227. You are requiring us to examine whether order passed by a tribunal in Hyderabad, beyond my powers, beyond my jurisdiction. Because 227 says tribunals within my jurisdiction. These two portions were, how can the interim order stand?
situation to get
That is why, Ms. Gayan, I had first asked you whether the approach by the petitioner to the tribunal is barred by law. That agreement cannot prevent him under that's what exactly in para 45. Para 45, Mr. Prasad, of that judgment this court has held.
contract not comes under main issue, my lord. Because this is a contract.
Have you, when you approached when you submitted your bids, have you projected that you are an MSME?
This, my lord, this issue has not come under the MSME Act. My lord,
He is an MSME. That act gives overriding power to every other. It has overriding power of all.
kindly say this is a.
You do one thing. You have a
Page
copy of
26.
that judgment. Just give it to her. We'll take it up after some time. Let her go through that.
Yes.
Ms. Prasad, let her, we'll not take her by surprise.
Right.
We'll just give her a copy and then you make your submission.
Yes, ma'am. Yes, the 2022 Act.
At 2, we'll have it. At 2.
It's,
Before that, how long will it take?
At 2, my lord, single bench will say, the court number 2, for only for my lord, my cases, my lord.
Okay, before 1. Mr. Sarab, what are you waiting for? What are you waiting for? 6. Oh, ha. We'll just finish up this. Yes, Mr. Sama.
Matter pertains to compassionate appointment.
Hmm.
Father died on 4/6/2015.
Hmm.
Then immediately after 3 days, my lord, he filed an application. Time, my lord. Is HSLC pass. These are the 3 documents I have annexed in the writ petition, my lord. Affidavit in opposition, my lord. They say para 8, my lord. They say that they are statutory organization.
Hey, State Financial Corporation Act to us. State. Statutory corporation.
Statutory corporation?
Under the State Financial Corporation Act of the central government,
Yes, 1950.
Parliament.
Then para 9, they say that we do not follow the compassionate scheme.
They say we don't have a scheme
Yes,
and we do not follow. The government scheme is not applicable.
not applicable so far as AFC is concerned.
Hmm.
The Corporation Act 39,
Hmm.
Section 39, my lord.
Hmm.
It is there, my lord. In the affidavit in reply, I have indicated, my lord.
That says that the state government can give instructions.
Instruction, my lord.
But it does not say that all the policies of the state government will be automatically applicable.
Or they can have a consultation.
But where is that thing that they had a consultation, they have a scheme? You have not said so. You say Article 12, so it will be covered. That cannot be.
No, in the affidavit in reply, I have indicated, my lord, Section 39.
39 is there. 39 is very clear.
If
It will
there is
not
doubt,
bring.
It's like a saving clause, my lord.
No.
If there is some doubt, they can.
Where is the dispute between the state and the board for 39(2) to come in?
And in fact,
Nobody has disputed. The state has not said you implement. The board has said we will not.
because state is a party in the proceeding,
Fine.
they have not filed any.
This is
affidavit.
compassionate appointment.
Yes, my lord, compassionate appointment.
And you see the 2015 policy. Well, if we say that that will apply, it says state government employee. Your father is not a state government employee. So there has to be an adoption of that scheme or a preparation of a scheme by the board, by the corporation. Both are not there.
39, my lord, there is, the question is, my lord,
Hmm.
39, in discharge of functions,
Hmm.
the board shall be guided by such instruction
Hmm.
on questions
Hmm.
of policy as may be given by the state government. So,
No. There is one word you missed out.
discharge of its function, the
Ah.
board shall be guided by such instructions on question of policy as may be given to it
To
by the
it.
state.
Where is the material to show that the government wanted the corporation to follow the?
My lord, my contention is, my lord, it's a welfare scheme.
It's not a welfare scheme. It's only a scheme to meet up the need at the time of death of the government employee.
In fact, my lord,
Even if I hold that there is a scheme today,
Lord,
that they were required, they had a scheme, the government scheme is covered. Still, I cannot pass a mandamus requiring a consideration after 10 years.
At least, my lord, lordship may direct for consultation.
Will not.
Because in the scheme adopted by the state government, the latest scheme, where that compassionate appointment has been abolished. In that scheme also, my lord, there is an indication that this will apply to the state government, provincialized employee and all other as eligible under Assam Services Pension Rules 1969.
You are not eligible under 69 rules.
Yes, my lord. In
You
fact,
are eligible. You
Yes,
get
ma'am.
pension.
they have mentioned, my lord. They have.
No. Do you get pension under 69 rules? You're getting pay. Mother is getting pension.
No,
Then-
some benefit has been
That is already there in the affidavit
affidavit they have indicated, my lord.
indicated. That is all like CPF.
CPF and this is a provident fund deposit with interest, gratuity as payment as per X and group insurance. So it implies that these
How
are the
can?
pension scheme.
How can? Where is your pension scheme under 69? Okay, there is no pleading. You show me, I'll accept it. That you are covered under 69. If you are covered under 69, then you assume a status of a government employee. Then that scheme will automatically apply to you.
That indication is not there. but
Not there. The only thing, Mr. Sharma, it cannot be there if you can come to internal page 3 of the affidavit. Para 10.
There are 10, my lord. They have
The
indicated.
first Roman 1. Provident fund deposit. So it is not GPF, it is provident fund.
Provident fund.
So finished.
Gratuity payment as per Act.
Act.
They have not indicated which Act.
Forget that. That is not the case also here.
And group insurance. Group insurance, of course, it's an
Yes, sir.
insurance scheme.
So, Mr. Sharma, how can we help you?
The thing is, my lord, that under 39, if your lordship directs
39, we are not convinced. Any direction given to it by the state. That's why I asked you, show me the material to show, or you're pleading that the state government had required the scheme of.
state has not filed any affidavit.
We will not ask the state to file any affidavit. You are appearing for? Corporation.
It should file affidavit and, my lord, they should indicate what.
In a given case, we'll ask the state to do that. Not here. Anything else, Mr. Sharma?
These two things, my lord, that new scheme also indicates that
That again says under the 69 rules. You're not a 69 rule coverage. You don't have coverage of 69 rules. You have the 2015 scheme with you. State government 2015 scheme.
no, I have got 17.
Just show me that
the
17.
Last one, my lord. Paragraph 4, 5.9.
That is that abolition of the
Abolition of the
compassionate appointment scheme.
compassionate appointments. Due thereof, they should get the salary.
The detailed scheme as below, provided below, shall be followed by all departments in the state government. It does not extend beyond the department, direct departments.
5.9, some indication. Yes.
Yours is that Central Administrative Tribunal requiring a notification. This is a requirement of notification, not the original. But yes, you have made out a point. We'll now have to deal with it.
We have got a staff regulation of 1957.
Hmm.
That I could not get the enter regulation, staff
But
regulation.
we'll have to go by the affidavit.
Staff regulation, there is some perimeter.
Because Mr. Sharma, when you have dealt with that paragraph wherein they say we don't have a scheme, you have not disputed it. You have only said that the state government scheme should be made applicable.
So,
Even in Debabrata Tiwari, if you look towards the bottom of that judgment, Supreme Court is very clear that there was no scheme. Then it says even if there was a scheme, because of the time lapse, we cannot pass a mandamus.
so far as Malab, this is a Malab, in which is.
There are decisions of the Supreme Court wherein Supreme Court has said, in absence of a scheme, no direction for consideration can be passed by any court.
That is why Malab, I prayed for time Malab, that 1957 regulation. I have the extract only.
Okay. Had Mr. S. Sharma, learned counsel, appearing for the petitioner. After making his submissions for a considerable period of time, Mr. Sharma submits that this matter be taken up on 19 Parine or Pundina Pari 26 on 26/8/2025 to permit him to make his further submissions on the matter. Prayer is not objected to by the learned counsel for the response. Accordingly, registry to list this matter again on 26/8/2025 for further hearing.
26 Malab, any other date Malab.
21 DB, 21.
Offline.
21.
That regulation.
You find out. You find out. I'm with you. We'll accept that prayer of yours and then reject your petition. But at least the position will be clear that in AFC there is a scheme that we will lay down, but you will not be benefited. Yes, where is the details? Written instruction with regard to the
Second is the.
Madam, can you file an interlocutory application? Bring it on the record because we'll have to have them on play. Otherwise, it's difficult. Rest assured, we are convinced that you are entitled to a compensation, but we'll have to get the persons in. In terms of the order passed by this court on 31/7/2025, Ms. R. Devi, learned counsel, learned CGC appearing for the respondent railways, has placed on record a memorandum of understanding for joint venture entered into by three firms for the purpose of submitting their bid in connection with the work of design, supply, erection, a page 60, A to A. 60-61 Janaka ase enake maidi ba? Full stop. A copy of the said memorandum of understanding, the copy of said memorandum of understanding as furnished by the learned CGC is handed over to the learned counsel for the petitioner to enable her to implead the joint venture partners as respondents in the present proceedings. Full stop. The said application be filed within a period of 2 weeks from today. Registry to list this matter thereafter along with the said interlocutory application. We are giving it to her. Matter be not treated as a parted and or tied up matter any further. Comes back to me, I'll look into it.
I've already submitted, your lordship, in fact, complete the hearing, my lord. And
We will be, Mr. No. One query, Mr. Maybe a nonsensical one, please.
141. The return is submitted.
Because I also get, once that process is complete, they give me that returns of anything, what do you call that? The return, whatever I have to get, they issue a 143-1 only.
143-1 is the, my lord, the return is to be submitted. If the notice is not issued under 143-2 for scrutiny, then after 1 year, the assessment is self-assessed.
Then they'll have to go to 147 and
147.
Hmm.
And 147, the second proviso.
Hmm.
The proviso, which says after 4 years only for information, that will not be applicable. But that is only in case where the assessment has been made under section 143-3. That means after scrutiny.
Hmm.
But the first part,
Hmm.
that whether the income has escaped assessment, that will be applicable.
applicable.
In this case, we are saying that the income has not escaped assessment.
Because you had set out that in your returns.
In the returns, everything has been shown, and they have mentioned that it was not offered to tax. It was offered to tax, but because of the provision of the Income Tax Act, it was the
Long-term capital gain.
capital gain. And second issue, we that 147 cannot be issued on the basis that the time is not there and we will make inquiry. That is not permissible.
That is the projection made.
That is not permissible. And there is no specific finding in the case of the petitioner that this was a bogus one. He is only saying about the general trend which is happening in respect of these companies.
Mr. Saraf,
I-
your case is that the shares that were with you, you transacted that further, you earn some profit there. Now, if it is beyond 1 year you have held it, then it will be a long-term capital gain. If it is shorter than 1 month, 1 year, then it will be a short-term capital gain, which is taxable. Now, I've been not able to comprehend. I'll ask Mr. Chetia also. How did this period that you had held the shares, the assessing officer come to a conclusion that this was disposed of before 1 year? That it will be a short-term capital gain, not a long-term gain?
That's why the chart has been given in the account.
No, that is, they are disputing. What is the material in the order?
There is no material. He's saying short term oblique long term.
Long-term.
He's not aware that
Ah.
whether it is short term, whether it is long term. And he's simply saying that in this type of transaction, generally this happens. Generally many things happens.
No, I know that. You may have committed a offense by trading with that firm. That is a thing which ED or the other investigating agencies can take up. But we are here concerned only with regard to the fact whether the income has escaped assessment. Long-term capital is your contention. So is it required, just as an officer of the court, I'm asking you,
I know.
is it required that there has to be a finding that, okay, he said this is a long-term financial gain, but these materials show
This
that,
short term.
that it is a short-term?
That is not the case at all.
Because in the order I have been trying, maybe I might have missed out. There is nothing of that sort.
That is not the case at all. That is not the case
That
at all.
should have been the case.
It cannot be because on the facts. that
They
is-
cannot dispute.
They cannot dispute. They are simply saying, my lord, that these type of transactions, generally this happens, that happens.
That is a general term.
In the Chugmal's case, my lord.
And your case is that I have not been transacting with that firm which is there. I've been transacting through a broker and they have never said anything about the broker.
And in the Chugmal's case, you also seen. Was a case where the person concerned said that I generally deal in the fraudulent entries. Only accommodation entries I provide.
Mm.
And on that basis, Supreme Court has said that he had not said that I did with him.
He said, I'm doing it on my own.
He's generally doing the work.
Hmm.
But he had not said that I have provided a fraudulent entry to the person concerned. Now, in this case, where it has been said that in my case,
There is a,
there is a
Fraudulent entry.
something. There nothing.
because these two aspects, maybe I'm wrong, I'll ask Mr. Chetia, are not there.
Lord, in fact, in this case, on the basis of the information, general information, whatever they have issued notices.
Reason to believe.
That it cannot be because it reason to believe has to be with the specific person concerned. Cannot be a general thing that it is happening in India. So everything, my lord,
There is an allegation. How the allegation would be relatable to Biswajit
to the
Dev,
person concerned.
to Biswajit Dev.
He knows that this type of things are happening. But that doesn't mean that everybody's assessment will be reopened. Cannot
Okay,
be
when is
reopened.
Mr. Chetia coming? Next week.
Has to be complete, Lord, because we have already completed. And he has to only give, Lord, he wants only to give the written submission, nothing.
By the
He wants to give only written
almost
submission.
ready, Lordship, almost ready.
Okay. Heard Dr. A.K. Saraf, Learned Counsel for the respondents, for the petitioner. Also heard Mr. J.P. Moore, Learned Counsel, appearing on behalf of Mr. S.C. Chetia, Learned Standing Counsel, Income Tax Department. Mr. Saraf has placed on record his written arguments. So, Mr. Moore submits that the written arguments on behalf of the respondents would be brought on record on or before Monday?
Monday.
On or before 11/8/2025. Also, registry to list this matter again on 14/8/2025 for delivery of orders. The other two also you're petting about that I have cleared.
I was
but-
searching for it.
No, you will get it today because the twice corrections have done. Today it will be, I think, uploaded.
Another one, whether tomorrow the matter is there, you'll also wanted that the written submission. to file. I've given.
Yeah, I'll go through it. Trying to learn.
Pleasure for arguing before.
Trying to learn.
7.
Mr. Rabba, anything
Yes.
is left out in this matters?
Not. Lordship here only.
Because the similar case was there. You were not here on that day.
Okay. But I have submitted, court reflected it, but the matter is separate. Issue is separate, that is segregated. T-tech.
No, it had come up together that day.
Yes, together, but that has been left out.
No, I let it out because there was no representation on your behalf.
Lordship.
What is left out to be done in your case?
My case is a land matter, it is a rehabilitation matter.
Huh?
Rehabilitation, because.
Rehabilitation already provided for.
And here.
Are you in contact with your clients?
Yes, yes. But only the respondent number 16, District Commissioner of Tinsukia has submitted reply, affidavit, others are not yet.
Do you have instructions from your client that they have not been given a rehabilitation recently?
Yes, yes.
You have.
Yes, good.
Why this discrimination?
Copy.
Hmm.
It is said, my lord, the original LOT of that forest land were 90, very less people, my lords.
You have filed an affidavit here.
No, well, I couldn't find this. I have to look at the records. Otherwise, my lords, the original people were very less.
No. You have given them, but what about the rehabilitation?
No government land is available, but we have compensated them and
Rehabilitate.
But here there is nothing. They are not even getting water, electricity, nothing. Paragraph 4 only. The people living in this set are deprived of facilities like electricity, drinking. But in the other case, oh. So where are they now? Where are they? Where are you now?
In the same place.
Same.
Same thing. In the, actually, the lordship, the original date, but the government of Assam declared it as a sanctuary, wildlife sanctuary in 1986. Thereafter, in 1919, it declared as a national, national park. And but the claimant, these petitioners and along with other villagers, co-villagers, it is numbering more than 2,000. They are living in the same place. And the government assured us that you live here, then unless and until we rehabilitate you somewhere.
How are you surviving today? How are you surviving today?
Others
How are you surviving today?
are when somehow we were getting or by our.
Mr. Gogoi, have your instructions.
Vice my lord, the original allotment was only 135.
Okay, fine, I got
Yes,
it. Because there was another case connected to this. That has been disposed of.
Civil service, my lord, the petition suo motu Kaziranga, these people will be in trouble.
Fine, if that be so, we'll consider. There's no problem. But in that Bhim Singh's case, WPC 353,
Infractors.
there was a categorical statement made by the petition.
After some days, I will get instruction that happened to this man.
But Mr. Learned counsel for the petitioner, as well as Mr. D. Gogoi, learned standing counsel, Forest Department, and Miss M.S. U. Das, learned additional senior government advocate, Assam. Mr. D. Gogoi, learned counsel for the petitioner, prays that he be given time till 27/8/2025 to receive his instructions as to whether the petitioner's hearing, as to whether the grievance of the petitioners as raised in the present petition has been redressed by the state authorities. Full stop. Ms. U. Das, learned additional senior government advocate, shall also receive her instructions in this connection. Registry to list this matter again on 27/8/2025. Let them have their instructions, because I was told in the last date that in one of the matters of the same area, the government had rehabilitated everybody. So let me have that instruction. What you have done there, prayer, just check the prayer in the writ petition and what you have done, that much only. Because there was already a submission made. That's why I'm asking.
Reports, your lordship, we have got the instruction, your lordship.
Mm.
So far as our instruction goes, your lordship,
Mm.
that 18 petitioners have not received the compensation, your lordship.
No amount.
No amount, your lordship.
How many
They have
petition-
said, your lordship, in their affidavit about 6. Apart from those 6 included, your lordship, another 17, another 12 has not received any compensation, your lordship. If your lordship permits, I will file a short.
You will have
affidavit, your
to.
lordship.
You will have to.
Lordship, and your lordship may take it up next week, your lordship.
No. Can you give the list? You have a
Yes, sir.
list.
That's the list.
You file an affidavit.
Lord, this list includes, your lordship, who has received how much amount of compensation and who has not received any compensation, your lordship. As for example, your lordship, 8, 9, 10 in the list has
These are the serial numbers of the petitioners.
only basic.
Okay. Mr. S. Bothakur, learned counsel for the petitioners, on instructions, submit that out of the petitioners in the present proceeding, 17 17.
No,
How many?
91, Your Lordship.
No. How many have to receive?
18 is to receive.
18 petitioners are yet to receive any compensation in the matter. Also, he has submitted a list of the petitioners and therein has indicated the amounts received by the other petitioners. Also, the names of the petitioners who have not received any compensation is also reflected in the said list. Full stop. Mr. Bhattakur shall furnish a copy of the said list to the
Already furnished, Your Lordship. I have already furnished.
I'm just making it formal, shall submit a list to the Learned Council assisting Mr. M.Z. Ahmed, Learned Senior Counsel appearing for the Power Grid Corporation, and to Ms. U. Das, Learned Additional Senior Government Advocate, Assam. So, the Learned Council for the respondents shall verify the particulars set out by the petitioner in the list so placed on record. Also, the petitioner shall also bring the said list by way of filing an affidavit in the
Yes.
matter. On the next date of listing, the Learned Council for the respondents shall apprise this court about the disclosure made from the list as placed on record today by the petitioners, by the Learned Council for the petitioner. A registry to list this matter again after. How long will it take? 2 weeks? 2 weeks will do. 3 weeks from today. And what about the 30%? That this 113263 that you have received is minus 30%.
That they have not received.
So can they receive that 30%?
That we've already said, whatever is due.
They can. Why don't you go and accept that? Yes, what is your instruction, Ms. Das? Sorry? No, where is Mr. H. Sharma? Where is he? Where is Mr. H. Sharma? You have Mr. S. Sharma here, H. Sharma, because he was supposed to take the instructions after some time. You all need not be here, I'll do. When Mr. Sharma is available, just tell him. Mr. Ahmed, you need not be available. We'll have the consideration next week. But if he has the instruction, we'll permit that this 30% because you want the particulars from them. Bank account and all.
It has to be details have to be furnished.
Furnished by the SDO. We'll do that.
Your Lordship, they fix a date.
I'll fix a date, don't worry. Not quite, but a date to fix. Itu baki kini, ya how my engineering.
May please your lordships.
2017 lordships.
Yes, what happened to the inquiry, Mr.?
Received the
But the inquiry has been, you have made a submission that the inquiry is underway.
and notices were issued by the Lower Assam Commissioner, but in the meantime,
And we are not concerned, but what happened to the inquiry?
the revenue department has said that time record is not available with them. But
Such a serious issue, this casualness, why?
sir, at one point of time, notices were issued. The deputy commissioner has also said. Should may give us some time.
Okay, the inquiry was to be done by the Commissioner, Lower Assam Division.
After the Lower Assam Commissioner department. Now that they have not,
But where is the records which were there with the Commissioner?
records have been, my lord,
Last 3 years, this is in a limbo. This will give us a very bad vibe of something more being there.
there is,
But that was sometime in
that's
23, 24. And you have done nothing thereafter. Who is appearing for the secretary? You are there. You are there. And you say that the inquiry now would be completed by the secretary of the,
by the
who is the head? Mr. D. Nath.
secretary, my lord, we have,
Okay. Mr. D. Nath, Learned, senior government advocate, submits that the inquiry as directed by this court by the order dated 9/9/2022 was to be carried out by the Commissioner, Lower Assam Division. However, after passing of the said directions, the post of Commissioner, Lower Assam Division was abolished by the government. So he submits that the records were relatable to the inquiry as directed to be carried out by this court is to be furnished, it was to be furnished to the additional chief secretary or to the head of the, to the revenue and disaster management department for continuing with the inquiry. However, the records have not been so transmitted.
a natural corollary that all records have been returned back. The revenue department has said they are not in a
So where is the records? Who will find it out?
department. See this, kindly see the secretary's letter. my lord.
No, how can it be so casual? Where is the records then? Did the Commissioner of Lower Assam institute any inquiry? Because your,
Yes, because notices were
so that there is that file where from where the notices were issued.
was with the at that
No, I got it. From Lower Assam Commissioner, you said on, you made a submission on 26/9/22 that the inquiry as required has already been initiated. So after this, what has happened? No, where is this file? RR.41/2022. Mr. D. Nath, Learned Counsel for the petitioner, has submitted that the inquiry as directed by this court by order dated 9/9/2022 was to be carried out by the Commissioner, Lower Assam Division. So the Commissioner, Lower Assam Division had accordingly initiated the inquiry and notices were issued to the concerned authorities. So, however, subsequently, however, the office of the Commissioner, Lower Assam Division was abolished. He submits that the Revenue and Disaster Management Department would now carry forward the inquiry and accordingly seeks accommodation for a week to apprise this court as to the authority in the department who would carry forward the inquiry and further as to whether the records basing on which the notices were issued in the matter by the Commissioner, Lower Assam Division, has been received by the department. Full stop. The authorities in the Revenue and Disaster Management Department are directed to immediately take into custody the records of the matter, including the file from where the notices in question were issued by the Commissioner, Lower Assam Division, and thereafter to continue with the inquiry as directed by this court by the order dated 9/9/2022. So, for the purpose of ascertaining as to whether the inquiry has been started by the Revenue Department, registered to list this matter again on 27/8/2025, on which date Mr. D. Nath, learned Senior Government Advocate, shall apprise this court of the developments taking place. Mr. Sharma, let's get this thing clear, then we will see. If not, if this is dilly-dallying, then we'll ask the CBI to come in next day. Because this is not a matter which can be let go. Very serious.
They indicated, but only because of.
Fine, we are giving you a liberty. We understand when Mr. Nath is saying something, there is something, we always have that faith. But ask your authorities not to dilly-dally this matter.
But I will take back that.
You take back. It will.
May I please, your Lordship? Lordship, I am instructed for the case, Lordships.
Rightly so. Mr. R. Sharma, Learned Counsel for the petitioner, on instruction submit that he be permitted to withdraw the present writ petition. Also, prayer is not objected to by Ms. U. Das, Learned Additional Senior Government Advocate, appearing for the state respondents. Also, in view of the above, the present writ petition stands dismissed on withdrawal. A letter to town after the. Mr. Nath, you can take back your letters also. Ms. U. Das, the Additional Senior Government Advocate, and Ms. N. Bodloy, Learned Standing Counsel, Revenue and Disaster Management, are present for their respective respondents. Yes.
Response number 2, 3, and 4 supposed to file an affidavit, Lordship.
Stand for vetting.
Okay, what is your parawise comments? Show me your parawise comments. How have you come to a conclusion that this land is a government land? But you have not dealt with the contention of the petitioner that he is taken that land from a patadar.
Yes, sir.
That is the categorical contention, and there is a lease agreement. You have not dealt with that aspect in the affidavit. This is the one only you are going to reproduce. What is the use of filing this affidavit?
Verification of the land lordship, Annexure D.
Huh?
There is a verification of land lordship. Agriculture officer Margarita.
Oh, agriculture officer is nobody to verify the land. Huh? Madam? No, he says that it is a patta land. You can come to page 20 of the affidavit of the writ petition. But don't file an affidavit for the sake of filing an affidavit. Deal with these issues. Ms. Yudas, learned counsel for the learned additional senior government advocate, submits that the affidavit on behalf of the respondents represented by her would be filed on or before. When are you filing it, Ms. Das? When are you filing it? No, give me a date. This is 2019 matter. We are not giving you much. Within this month.
In this 29th.
On shall be filed on or before 29/8/2025. It is directed that in the said affidavit, the respondent shall deal with the contention of the petitioner that the land taken by him on lease for construction of the factory in question was so taken from a patadar and the details of which is given in page 20 of the writ petition. So, registry to list this matter again on 5/9/2025 along with the said affidavit. In the event the affidavit as directed as undertaken is not filed on the next date of listing, the district commissioner or the additional district commissioner Margarita shall be present in the court along with the connected records for assisting this court in disposal of the present petition.
Interim order may be continued.
Interim order to continue until further orders. Where is the counsel for the respondents?
All lordship that we take.
What is left here? 2 years holiday notice that is already gone. I'll close the writ petition by saying that this is already over. Don't take any coercive action basing on that against you. Finished. What more is required to be done here?
Because the English Council Lordship Hikesh was out of station on Monday Lordship.
What? When did he go out of station?
12/8/2000.
So why have you not submitted a note, adjournment note? Who is appearing for the respondents? A prayer is made on behalf of the learned counsel. On whose behalf you are making this prayer?
Hikesh Chopra.
On learned counsel is prayer is made on behalf of Mr. V.K. Chopra for an accommodation in the matter today on account of the fact that he is out of station. Prayer is not objected to by the learned counsel for the respondents. Registry to list this matter again on 26/8/2025.
There is interim lordship.
What is the use of that interim order today? Interim order to continue till the next date of listing.
Council, Mr. M.K. Chaudhary is appearing. He's in legs in court number 4, your lord.
After some.
Public.
Second round of Mari. Mr. Saraf, Dr. Saraf, your matter, 18. Matter, matter 2 till matter. Round up. 18. 18. What has happened? You have asked the respondents not to come.
The issue which is involved in this present repetition,
Interesting issues.
but the cement which was supplied to Arunachal, its price was different for Arunachal Pradesh. After the introduction of the GST, GST has come, thereby the tax implication will be different. Communication was sent below that the best, whatever best price will be there earlier, that will remain the same, the tax element will be different. And they agreed to it and accordingly we supplied. Now thereafter, after supplying, they are saying that the base rate cannot be different after the introduction of the GST.
That may not be correct. Are you taking a amount as freight also? Component?
Yes.
That is extra.
Separate.
Extra.
Yes.
Then why this difference of rate?
It is a contractual melody.
But that was in pursuance to a tender, they had accepted that.
They have accepted.
But there is another point, plea that has been
That is the
taken.
main point, Milord, that the excise they are now demanding 8 crores.
Oh,
Milord, there was a policy, as you also knows, that excise, whatever is there, for new, it will be exempted. Now, in that case, the levy is not exempted. I have to collect it, deposit in the government treasury. Depositing in the government treasury, the same is refunded back.
oh.
Now, they are saying that this excise which was exempted should
Should have been passed over to them.
passed. Now, if it is passed over to them, the amount, then the
You say that the scheme is for my benefit. That way, where will
scheme
it go?
itself will go because it is in the nature of subsidy.
And what is the position after the GST on discount?
So GST, after that, the excise exemption is gone,
On.
but there is a budgetary scheme
Hmm.
by the central government.
Hmm.
That Milord, the amount is given back. 50% or something is refunded back.
Hmm.
That is altogether different in 17. But now they are saying that whatever you have from 2007, you have excise, whatever you have got back.
You
that's
give it to
refunded.
us.
Now, Milord, as you also know, Milord, in the bill, I have to charge the excise duty. I have to pay the excise duty to the government.
Hmm.
15 days, the excise duty is refunded.
Hmm.
Now, if the amount is given back, then the very scheme and the policy will be redundant because there is no meaning of it.
Because this is for your running of that industry, you satisfy something, so you get it.
So that is a different scheme for the encouragement of the establishment of the industrial units in a area. And that benefit, whatever I get, that is not to be given. In fact, similar situation came up for this honorable court, Milord, where the cinema halls, Milord, these multiplexes,
Hmm.
there the exemption was from payment of this entertainment tax. Now, the person concerned was collecting the
Tax.
tax and was not making payment to the government. Government said, Milord, that no, since you have collected it, thereby you have to give it back to the government. Matter came up with this honorable court, and this honorable court held a division bench that no, policy is only for the purpose of the policy in this as per the section, and the payment is exempted. Levy is not exempted. The levy is there.
Hmm.
So collection and keeping it will not amount to violation of the provisions of the act.
Hmm.
If the levy is exempted,
Then you cannot.
then I cannot collect. But levy is not exempted. If levy would have been exempted, Milord, the question of payment of the tax to the government treasury would not have arisen. at
Here
all.
also levy is not exempted as far as that excise duty is concerned. Their only case is that you should have refunded it to us.
That amount should.
And what happened to that difference of rate? What action have they taken against you?
They have said that 84 lakh something was receivable to me. They have deducted around 26 lakhs they have paid. Balance they are saying that we will not pay because the difference is there.
So there are two issues. One is that rate,
So when I objected, then they have issued a notice further to me that now. for
excise duty.
Excise duty, 8 crores, 7 crores, that will be. We are challenging both.
Just for my understanding, I'm hearing.
Sure.
What is your stand? 2 points. You entered into a contract with him.
We entered into a contract with him and as was supposed to disclose.
Fine, that will come later. That will come later. That will come later. That will come later. First point is that he had quoted a particular rate with you. You accepted that. A contract was formed. Now, can you resile back on that?
If he was had to make any disclosure.
That will come. We'll come to that. We'll come to that later. We'll come to that later. Excise, GST, whatever is, we'll come to that later. With regard to that rate, because admittedly your stand is that he was having two rates. One for Assam, one for you.
Yes.
So, but you, that rate had come to you in terms of a contract.
No.
Tender.
No.
You accepted that. So now can you resile back on that?
There is one thing which your lordship has. Once the GST difference will.
GST is different. That is additional. The rate first I'm asking you. He quoted 200 for you. In Assam, he was quoting 100. That's one of the issues. Yes, Mr. That is one of the issues. What do you say on that?
Perhaps.
So that is gone. So that is gone. With regard to excise, subject to what just for my understanding, what Mr. Saraf would finally say. If the levy is barred, then he cannot ask you to pay that amount because the levy itself is not required. But here, under a different scheme, because of setting up of an industry here, he has been given an excise exemption. Exemption means that he will have to collect the levy. He will deposit that levy with the government and the government will refund that to him. If he has to refund that to you, how will he, that scheme that was there for his benefit, that will not be there. Because this industry was set up here seeing all those things only.
Yes, lordship, that so far as what I would be honest, he have charged the excise, then government would have refunded on the subsidy part.
Because here in this, that rate that he had quoted was an inclusive rate. Not inclusive. That rate had extra.
Excise extra, my lord.
Extra.
Of the excise, that is why we have paid him.
Okay. I think it's inclusive. The rate was inclusive, Mr. Saraf.
I'll tell you that the excise duty and also if he's exclusive, as you also knows that term inclusive means that you have to pay this amount. You are not concerned with the
Excise. That is for you to take out and pay.
If my learned friend says that is inclusive, then he's not concerned whether excise duty was 5%, 3% or exempted, no concern at all. That
Even
is-
if it is inclusive, as far as your books of account will be there, you will have to show this excise component separately.
Definitely.
Now, the issue is whether this excise money refund that is coming to you would be required to be again transferred to the.
I will just, but when I raise the bill, I have to charge it because the person in normal course, the second person who purchases, he takes the standard credit of that excise amount. Now, although the amount is refunded back to me, but that person
Is getting that credit.
that gets the credit. Because the government is giving back me, but it is in the nature of subsidy.
It's a subsidy basis.
Establishment of the industrial units. But the another person who is purchasing from me, he's not denying the benefit.
He is getting that Senvit credit.
He's getting the standard credit. He has to get it. Now, if in case I have to give the amount back,
Double enrichment.
then where is the question of the getting the benefit of
But they,
100%.
in their affidavit, have not said anything about the Senvit credit.
But that is a scheme, my lord, that it has to be charged.
They'll have to charge.
So in the bills, it has to be charged
By you.
by me. And once it is to charge, my lord, and similar issue came up before the Chief High Court also, my lord, where the issue was that whether the excise duty is exempted. Now, the issue in this case, the court came to conclusion, this is not exemption. This is conditional exemption subject to the fulfillment of the conditions laid down in the municipal policy. The goods are not exempted. Neither the goods are exempted nor they are leviable at the zero rate of duty. In the Excise Act, if it is exempted, my lord, then
There'll be a list.
and there zero rate not leviable, my lord, then separately it will be there. These are not exempted.
These are leviable. You have to
Separately
levy,
said, my lord,
pay.
exemption cannot be there unless and until levy is there. If levy is not there, where is the question of exemption? Exemption will come only when there is a levy. Now, if the levy is there, then I have to charge it. And I have to charge it and I have to, now whether to make payment, in certain cases, my lord, the government has formed a policy, like in the VAT Act it was there, that you collect it, but pay only 1%.
Okay. You collect 3%, you pay 1%.
You collect 100%, but you have to pay only 1% of the tax.
Okay.
So 99% I can retain it.
Retain it.
Now somebody can say that this 99% you have returned that you give me back to me.
That cannot be.
That will be against the policy and the scheme itself.
Okay. When can we hear it? Today it's not possible.
Because
No, today I am not ready because
point he has accepted. I am
That
entitled
is
to
gone.
60 lakhs.
Hmm.
Now he is asking for 5 crores more.
more, 8
Whether-
crores.
Whether he entitled to not. That,
8 crores. So one thing we have resolved today.
but I asked for 60 lakhs more.
Hmm.
Then he said, okay, I asked for 8 crores now.
So one issue is resolved. So the second issue we'll hear. Either
I will
way,
get triple benefit.
either way,
I may get,
that would be a submission of Dr. Saraf also against you.
I may get triple benefit from the government.
But whether you have to
But
transfer,
whether it is passed over. If it is passed over, then what for I will establish the industry?
or there can be a situation wherein you say that the goods is 100, you are getting back 30 rupees because of the excise. You can quote a rate by giving further 10 rupees. That is a quoting rate up to you.
That is the contextual, my lord.
That is in the first instance.
And even subsequently also, they may enter into a contract with any rate. But they cannot say that the excise benefit which you got, you give me back.
But Dr. A.K. Saraf, Lanark Counsel for the petitioner, also heard Mr. R.K.D. Chaudhary, Lanark Deputy SGI, appearing for the respondents. Pleadings in the matter is completed. Parties have agreed that the matter be taken up for final consideration on
Yes, my lord.
earliest would be 26, but 26 or at us, 28?
Yes, my lord.
Who does it? Second, 29, earliest.
Recorded at least the first part they agreed.
No, we'll not put him into trouble. That's an agreement we know, gentleman's agreement.
He's very fair, my lord, at least.
Mr. Chaudhary is fair,
My lord, at least
but you got to be careful with the fairness also sometimes.
I'm not doing, my lord, something beyond what I am entitled to, he has agreed.
We
Now,
will,
what he's not entitled to, he's trying to defend that, we'll see.
let's see. Let's
Let it be finally.
Let me find out. Mr. Dr. Saraf, just remind this court, we will remind. 2 issues, 1 issue is gone, only 1 has to be taken.
I will also prepare with along with the judgments, my lord, the written everything advance with the copy to you. Yeah.
Always be a learning experience. You also. Now,
I'm obliged, my lord.
thank you. Yeah. Mr. Sharma, any information here?
Somehow, Lordship, I missed the.
উপর তুমি ইউডাস লিখিছা নহয় এটো H শর্মা লিখিবা আইটেম নাম্বার 1617
8, item number 8.
8 sorry ইউডাসৰ জায়গাত H শর্মা লিখিবা Mr. Sharma তলত লাষ্টত লিখিবা Mr. Sharma H Sharma learned government advocate submits that he be granted further 2 weeks' time to complete his instructions in terms of the directions passed by this court by the order dated 30/7/2020. Accordingly, the registry to list this matter again on 29/8/2025. 29/8.
Lordship.
29/8/2025.
What's all that?
Okay. On 1/9/2025.
Lordship.
It's all full, that's why.
20.
Wait. This was passed on 28/7. You have not been able to. Only I want to know why it was done. That's all. Mr. R.M. Das, Learned Standing Counsel, NC Hills Autonomous Council, prays that he be granted time till 22/8/2025 to complete his instructions in terms of the queries raised by this court-wide order dated 28/7/2025. No further adjournment shall be granted in the matter to the respondents. Full stop. Registry to list this matter again on 29 Kushiluni, 29/8. Submission of 29/8. No, submission 29/8 bole question. Same date only.
10/22.
In these two cases,
When?
W has filed the affidavit day before yesterday, my lord. Not just.
Mr. Goswami, you are appealing for the PWD. Oh, Ms. M. Das, you have filed the affidavit. No, who has filed the affidavit? Mr. Dinar, Learned Standing Counsel, PWD, submits that the affidavit on behalf of the respondents represented by him has already been filed. So, the petitioner submits that he be given 2 weeks' time to bring on record a rejoinder to the said affidavit on behalf of the petitioners. So, registry to list those matters again after 2 weeks, along with the affidavit filed by the PWD respondents and the rejoinder thereto that has been undertaken to be filed by the petitioner. Also, 2 weeks question on a date to be fixed by it. After 2 weeks, on a date to be fixed by it, along with the affidavit. Get it? The stands are clear now. Now you make your thing, we'll finish it up.
What is 23/58?
Fine. Rest. Yes.
Pass the order, my lord, regarding first order, my lord, that they are directed to furnish the patra to.
No. What happened after that? They have already furnished the pattas. What have you done after that? That is why we are waiting for. You wanted to file an affidavit. You have not filed an affidavit. And you have not disclosed as to what the steps you have taken. Mr. Tiwari, be relaxed. Yes. If we had to dispose of the matter, we could have disposed it of on that day itself. But we said, what exercise have you done after that?
That exercise has been done. That instruction.
That is the instruction which is pending, Mr. Chutia, from April 2022. More than 3 years. We'll ask the secretary to come down then if they are not giving you that instruction. Because this cannot go on. They have submitted the documents.
My instruction is that.
Okay, fine. You have a telephonic, but give us that in black and white. What have you found with regard to the petitioners? We can't have a Mr. Chutia is saying, so we are accommodating, but no more further accommodation. Mr. Tiwari, let's say, you are protected. Mr. A. Tiwari, learned counsel for the, heard Mr. A. Tiwari, learned counsel for the petitioner, and Mr. J. Chutia, learned standing counsel, KAAC. KAAC. Mr. Chutia submits that as a last chance, he be granted further 2 weeks' time, 3 weeks' time to file an affidavit on behalf of the respondents represented by him. He has submitted that the inquiry, that the verification of the land documents of the petitioners have been completed.
Have submitted, my lord.
Land documents of the petitioners, comma,
We all have submitted, my lord.
who have submitted their such documents have been completed, and in the affidavit that would be filed, the verification reports with regard to each of the petitioners involved in the above noted writ petitions shall be brought on record. Full stop. Registry to list this matter again on 10/9/2025. In the event the affidavit is not filed on or before 5/9/2025, comma, who would be the person? Secretary Revenue, Karbi Anglong Autonomous Council shall remain present before this court on 10/9/2024 along with the contemporaneous records and the verification report with regard to the land documents submitted by each of the petitioners in the above noted writ petition, comma, for assisting this court in disposal of the present writ petition.
Orders passed earlier.
Interim orders passed earlier to continue until further orders.
Deeply obliged, Your Lordship.
Yes, what has happened? What is the status of the land, Mr. Goswami?
Occupation of the forest department. This
No, I'm not on that. Is it revenue land or forest land? It is under occupation, no doubt about it. We knew it from the day one. But your query was whether it is forest land or revenue land. 2 o'clock. I am calling your director here, your deputy commissioner here. This is too much. This is too much. This is going beyond. 2 o'clock. Whether it is revenue land or forest land. Yes, Mr. Gogoi, forest land or revenue land? You are under occupation, that is different thing altogether. But whether it is revenue land or revenue land occupied by you or forest land occupied by you. 2 o'clock. Yes. Wait. Wait. 28. When did you write to the deputy commissioner? 30. Today is around 13 days. He cannot give this instruction. 2 o'clock. Okay. Mr. N. Goswami, learned counsel for the petition for the learned government advocate appearing for the 2 and 3 submits that he be granted time till 13/8/2025 to complete his instructions in terms of the directions passed by this court-wide order dated 28/7/2025. It is stated that no further adjournment shall be granted in the matter. If not, on that day, we are getting your district commissioner. There was 2 days delay. So by reaching also maybe 2 days delay. That's why we are giving him one more chance. Yes, what is your instruction? We know that is why they are here. If there was no dispute, how could we have touched this matter? So whether the land of the government, the petitioner has been taken over for construction of the road. That's your case? Yes. Oh, this is that land, sorry, this is that boundary dispute. Yes, what happened? Where is your letter to the the deputy commissioner? When did you issue? When did you issue the communication to the?
I have received the instruction also.
Oh, yes, give me. Then why are you not saying that? Rightly so. This is the only thing we require, Mr. Goswami. Just give it to us. Yes, you are the creator of all the problems. You have gone and occupied land in 1451, which was the part of your 1640. You brought some part, it became 1460. You have occupied in 1451. That's why they have not issued that objection. Is there? How can they issue? Finished. We are dismissing it. Heard Mr. R. Fukan, Learned Counsel for the petitioners. Also heard Mr. N. Goswami, Learned Counsel, appearing for the respondents. Respondent number 4 and 5. Also, the petitioner in the present proceeding has raised a grievance with regard to the non-issuance of NOC by the district authorities of Tinsukia, Gulaghat for setting up of a retail outlet of the Indian Oil Corporation, Indian Oil-AOD. Indian Oil, what is it? Indian Oil Corporation, for which he was issued an LOI on
29/12/2020.
29?
12/2020, Lords.
29/12/2020. Also, the petitioner not being in a position to submit the requisite NOC from the district authorities, they said letter of intent, bracket LOI, was cancelled on
Hold on. Annexure 8, 5, 15/11/2020.
was cancelled on 15/11/2022. Also, accordingly, the petitioner has instituted the present writ petition. Also, on the last date of listing, Mr. Dilana, Government Advocate, was directed to receive instruction with regard to the exact reason for not issuance of no objection certificate to the petitioner herein, and as well as the stage at which the resolution of the boundary dispute between the petitioner and the landholder in DAG number 145451 and 1493 was pending. Mr. N. Goswami today, on basing on has placed on record the instructions received by him from the District Commissioner Gulaghat. A perusal of the said instructions would go to reveal that a parcel of land measuring 3 kathas covered by DAG number 1460, Patta number 372, was bought by the petitioner from one Bokul Soikia. Also, the land bought by the petitioner and covered by DAG number 1460 was originally part of DAG number 1451. Full stop. It is projected that in addition to be in possession of the 3 kata of land brought and now covered by DAG number 1460, the petitioner herein is occupying additional 12 lessa of land of DAG number 1451 and had made constructions thereon, which has led to the blocking the egress and ingress of the said Bokul Soikia and one Rijumuni Soikia. Full stop. Accordingly, it is projected that criminal cases have also been instituted in the matter by said Rijumuni Soikia against the petitioner herein. Full stop. In the said instruction, it has also been highlighted that due to the said land/boundary dispute, the circle officer at the relevant point of time had not issued the no objection certificate for setting up of the petitioner of the retail outlet of IOCL. Full stop. The non-issuance of the NOC being on account of a act perpetuated by the petitioner, which had led to a boundary dispute, and the same having not been resolved, this court does not find any error on the part of the IOCL authorities in proceeding to cancel the LOI issued to the petitioner, by way of issuance of the impugned communication dated 29/12/2020. Full stop. The resolution of the boundary dispute, which was created, which also had the active participation of the petitioner herein, having not been resolved, this court also does not find any error on the part of the circle officer of the jurisdictional circle officer in not issuing an NOC in the matter. Full stop. In view of the above position, which has come to light in view of the instructions placed on record by Mr. N. Goswami and which has not been disputed by Mr. R. Fukan, Learned Counsel for the petitioner, this court finds that the present writ petition is devoid of any merit and accordingly the same stands dismissed. However, there would be no order as to cost. The instructions furnished by Mr. N. Goswami is kept on record and marked as X for the purpose of identification.
Only thing is that communication is dated 26/11.
26/11 of?
12 of LOI lots.
Withdrawal of LOI, 26/11.
Obliged.
26/11/20?
2022.
2020. Mr. Fukan, you are the perpetrator.
Lordship.
You cannot have
Obliged.
the cake and eat it also.
Item 3.
Yes, madam.
But this is not my case, my lord. My case, yes, my lord.
Show me the relevant paragraph where you have said that.
Case of arbitration clause, my that is
Arbitration clause is already dealt with.
whether the work or not.
That is also gone into. Para 45 onwards, you see. Why was not it taken up on the last date? When?
Up to occasion, it did not reach, my lord.
Or did not reach? 31/7.
1/7 and thereafter also, my lord.
Yeah.
It did not reach, my lord.
list this matter on 4-8 in the column of stay vacating. It was
Came
not,
upon court, but it-
okay. So this interim order, we'll have to vacate. Vacation would mean that the writ petition will be not maintainable. You go before you have your instructions. We write something, it may even go against you. Have your instructions, go before the jurisdictional high court and get this thing resolved. Have your instructions. What time we'll take it up?
2:30, my lord.
2:30. Because we are convinced that 227 we cannot exercise. And even if I say, we ignore that plea of the Mr. Prasad and we hold that, yes, because there is an agreement, so that will have override everything, and it's only that method that would now be open to the petitioner. But that has also been stopped. That is also barred by the decision of the Honorable Supreme Court.
2:30, my lord.
2:30, done.
37.
Lordship, the conducting council might.
Okay. A prayer is made on behalf of Miss Toshinella for an adjournment in the matter on account of, on the ground that she is recovering from an accident suffered by her. Full stop. Prayer is not objected to by the Learned Council for the respondents. Raised it to list this matter after
4 weeks, ma'am.
4 weeks on a date to be fixed by it. In the meanwhile, no, in the meanwhile, no.
Please, your lordship.
Mm.
This matter, we have challenged the of the respondent IRCTC, the impugn communication. Submission, they are not empowered to frame the policies of modalities without the approval of the board.
What is the stand of the railway board here? Any affidavit?
No, railway board has not filed, but my learned friend who appears for IRCTC has filed.
You have also not?
But it is not
Filed.
on record.
That's what I have not filed it.
Yesterday, I have filed.
Okay. You have got a copy? You're not filing any reply?
I'll file.
When? It is submitted that an affidavit on behalf of the respondents number
3, 4, and 5.
3, 4, and 5 has been filed on
Day before yesterday. Lord.
That is 11/8.
11.
on 11/8/2025. However, they said affidavit is not on record. Also, registry to trace and tag the said affidavit along with the records on the next date of listing. Also, the Learned Council for the petitioner is granted liberty to file a rejoinder to the said affidavit if so advised. Also, heard Ms. B. Chaudhary, Learned Counsel for the petitioner, and Mr. G. N. Sahewala, Learned Senior Counsel, assisted by Mr. A. Singh, Learned Counsel, appearing for the respondents number 3, 4, and 5. After Kiman 2 weeks till 3 weeks go yeah.
Interim to continue.
Interim to continue till the next 2 weeks at all to the next date of hearing. But Mr. Sahewala, what is your stand that after the matter was entire catering was given to the IRCTC, the policy decisions also can be taken by the IRCTC? That is the any document, any document to that effect in the affidavit it is there.
May I please, your lordship? It pertains to non-payment of. Of course, to file the.
3 o'clock. Time only.
A week's time, lordship.
I have not filed an affidavit We have not done anything. There was an earlier round of litigation. Therein directions were passed. Then what happened? (25)(9). Learned Standing Council, PWD. 2 weeks time. 18/12. 2 weeks time. 3 weeks time. It's only that we are doing. Mr. B. Chaudhary, Learned Standing Council, PWD, submits that has a last chance he be granted time till 1/9/2025 to complete his instructions and file an affidavit in the matter. Full stop. The said affidavit, Mr. Chaudhary, the said affidavit has been undertaken to be filed on or before 1/9/2025. Full stop. In the event the affidavit is not filed on or before 1/9/2025, on the next date of listing, the Executive Engineer, Public Works Road Department shall remain present in person before this court, along with the connected records, and assist this court for assisting this court in disposal of the present writ petition. Also, registry to list this matter again on 3/9/2025. And also deal. Now, this work he had done at that point of time. So at that point of time, it was 22 lakhs odd that he has to give. Now, today, if you have to retender that work, you will not get it in 22 lakhs. There will be a rise. That means the money value has fallen. So we'll have to compensate him for that also. It is up to him. He says, I don't want, and we have nothing to say. But if he presses, it will be with interest. We'll not permit this thing to go on now.
Supposed to file an affidavit. We have received further some.
Only limited question, whether the land where you have constructed the road also involves the patta land of the petitioner.
Lordship, the road where it has been for decades being used by everyone.
Forget decades.
No point of time.
Okay,
and
forget
it
it. Forget it.
That's
Whether that involves a patta land.
Lordship, that has been subsequently by the
Very much clear, my lord.
at that point of time.
Very much clear. Where?
39, my lord.
39. Okay.
Affidavit, my lord.
Very much clear. Okay.
Get it, my lord.
Okay. Now, what do you want? Compensation. How much? Up to me. Okay, 10,000 rupees. Enough. Mister, we are trying to get it done. Please have some patience. Yes.
Lordship, can you pay?
Forget it. Tell me.
In the pre-existing road,
Forget the pre-existing road. No proceeding was done. So he is entitled to compensation. Yes, who will now do it? Mr. Talukdar, your deputy commissioner has to take up the matter. Determine.
Some portion of.
Yes. So estimate that, prepare the acquisition thing and pay him. We are not disposing of the writ petition. We want that process to be done. So your deputy commissioner will now do the needful in the matter and then place it before the PWD authorities for release of money. Also, Mr. B. Chaudhary, Learned Council for the Learned Standing Council, PWD, submits that although when the work in question was being executed, it was not highlighted that the road under construction also was so constructed over a portion of the patta land of the petitioner. However, subsequently, the district authorities have informed the said aspect of the matter to the PWD authorities, right? Also, further, in the writ petition, the petitioners have Further, the petitioners, by way of filing an additional affidavit, has also brought on record a communication dated 22/4/2025 issued by the Circle Officer, Borkhetri Revenue Circle, to the District Commissioner, Nalbari, wherein it was highlighted that a portion of the patta land of the petitioner was encumbered without any accusation proceedings, for the purpose of construction of the said road. Subpara. In view of the admission made in the matter by the respondent authorities, this court directs the Deputy Commissioner Nalbari to compute the compensation that would now be required to be disbursed to the petitioner and place the same before the Secretary, Public Works Department for a release of the funds. First off, the said exercise be carried out within a period of 1 month from today. Full stop. The Mr. R. Talukdar, learned government advocate, shall communicate the shall download a copy of this order and communicate the same to the District Commissioner Nalbari for compliance. Also, registry to list this matter again on Bondo on 15/9/2025, on which date the learned counsel for the parties shall apprise this court about the developments taking place. Now you are happy?
Happy. 43.
Question, my lord, last occasion, respondent number time to file affidavit, my lord. Government has filed affidavit, paragraph 12. stated
Okay,
that
you have received part information
part information and regarding
from one. What steps have you taken after that? What did that information relieve with regard to the other?
my lord, as per dear stand, my lord, the
No, forget your stand. I am not with any one of them. I am with there were two floor mills against which you had sought information. You got with regard to one.
one.
What steps was there? Everything was okay there. Everything was okay. Okay. So there was no read. Okay. Yes. Who is appearing for respondent number 6? Forget time. But why is this information being withheld, Mr.
Your Lordship may see at page 23. From 2018 to 2022, now there's
No, it is only the allotment copy has been furnished to them.
it's related to
The other things have not been furnished. He had asked for a number of documents.
Yes, yes.
At page 14. Why is this documents not being furnished?
They are saying that these are not available from 2011 to 2017.
Why? Where did it go?
It's up to the office, my lord. Then
Not the office. You have it. You are the respondent number 6. You should have it.
that, my lord,
Because this application was transferred to you. Why was it not thereafter?
copy they
It has to be there. Or there will be Mr. Toto. This is a writ court. If an illegality comes to my notice, I can proceed further.
power your lordship has.
So this withholding will give rise to an apprehension.
The reason, my lord,
There is some cloud here.
that way, my lord.
No, I'm not thinking. Don't make me think that way.
Your lordship, give me another chance.
Don't make me think that way. You make an undertaking that you are furnishing the information within a period of how much?
3 weeks.
No, 2 weeks. And then we will see what can be done. If you don't have the documents, make an explanation where the documents have gone, how the documents have gone.
Well, my lord, that I can do. But your lordship kindly give me 3 weeks.
For that, I'll not give you 3 weeks. If you want to make an explanation, want to file an affidavit, I can give you 1 week maximum.
Or affidavit.
Affidavit. Okay, Mr. Dotto is praying so. Heard Mr. N. Sharma, learned counsel for the petitioner. Also heard Mr. S. Dotto, learned counsel, learned senior counsel, appearing for the respondent number
6.
assisted by Mr. Deka, you are assisting. Your two is for? Okay. Okay. Assisted by Miss K. Bora, Learned Counsel, appearing for the respondent number 6. Mr. Dr. Learned Counsel submits that he would file an affidavit on behalf of the respondent number 6. That submits that he be granted time till 27/8/2025 to bring on record the an affidavit on behalf of the respondent number 6. First off, prayer accepted. Registry to list this matter again after. List this matter on 1/9/2025. Also, the respondent number 6 shall invariably file the affidavit undertaken to be filed on or before 27/8/2025. Also, in the said affidavit, the respondent number 6 shall explain as to why the information sought for was not furnished by it to the petitioner, although the matter was transferred to it on
'22 also, my lord.
date
13 to 2024.
13 to 24, and thereafter reminders were also issued in the matter. Full stop. (16).
Past 16, then 22.
22/3/2023. 22/3/2023. 22/3/2023. Also, registry question to 19. Oh.
Yes, even.
Wait.
Plus, they have
Why?
got an appeal, your lordship.
Only that thing. Why that appeal is being kept pending? It's a statutory appeal.
Yes.
A review can be made. Why is it kept pending? Why is it kept pending? Why? That is the only thing you were required to take.
Yes.
So part instruction is no instruction here. When did you file that review? Appeal before the
Appeal on 9/11/23.
9/11/23.
Lecture D.
Okay. Now, show me that you are a member. Your only statement is that you are a founder member, whether you are a continuing member. A stranger can't have a role in the internal workings of a cooperative society, can it? Where is that is the categorical finding? Where is that material?
Page 12, annexure A1.
12A1.
So this was issued by the.
Okay, what is this finding then of the registrar at page 15, last line?
Last line, yes. Is 16, lordship.
Page 15,
Yes,
last line.
During the course of hearing, Kamal Sodhi was asked to submit any document that prove he is or was a member or shareholder of the society. He could in his support. So Venus Mishra was the accountant of the society. Them cannot be accepted under section.
Now, where is your statement with regard to that finding in your writ petition? That is the issue. Whether you are a member or not, where is that material? You have shown me 12, fine. That is the initial one, 96. This order is of recent, 23.
23.
So where is your finding that that conclusion of the registrar is wrong per us? If you are not a member, I think cannot. Mr. Counsel will take it up at 2, you find out. Otherwise, I think we'll give it a closure today. And in the meantime, you take your instruction what has happened.
Fine.
Made please, Lord, sir. And the issue involved.
No show cause notice.
Is covered by the coordinate bench order. I have given the order, my lord. I have issued only summary along with the attachment, my lord. This is not a requirement of law, my lord. And in the affidavit, I have admitted, my lord. Party lordship will find para 29, my lord. Page 24, internal page.
Yes, Mr. Borua, what do you say?
May
There was 10.
Para number 4. Form DRC, that's what has been said by this court, saying that that is not the substitute to the normal show cause. So, we'll dispose it off in terms of this. We'll say that both the parties have consented, this order is passed. Whatever is their consequence for dispose of.
Here, my lord, saying for release of case amount they have seized as well as articles, my lord. Section 67 of CGST.
You're not filing a rejoinder there too?
Question of law only, my section 67, whether they can withhold the goods beyond 1 year, my lord.
Now, the issue taken herein is whether the money can be treated to be a goods.
Subsection, my lord, the definition of goods is there, my lord. It excludes money.
It excludes money.
Yes, my lord.
So, okay.
The judgment of the Gujarat High Court also, which is held, my lord.
Yes, sir.
Technically, Supreme Court.
The goods will also include money. So how do I know what is the interpretations? No, that the same issue is involved. How do I know? So Delhi High Court said this is permissible. That's beyond.
Dismiss one SLP file against the judgment of the Kerala.
It has now again issued a notice. Okay, we'll wait.
Now, lordship will see more than 2 years elapsed. There is no so cause notice. Lordship may kindly section 67. If they cannot withhold the money for indefinite period of time, my lord.
Okay, we'll consider that.
And lordship,
We'll hear the matter. Don't worry. We'll hear the matter.
Case notice 5.
No, your case is that the son of the main person has already passed on. His son was authorized. He had made statements before you, but after around a month or 2, he comes back and withdraws. And what is the stage of the investigation? So you proceed.
so cause, my lord.
You proceed. If somebody does not come and cooperate, are you hands tied? You can always draw conclusions. You proceed. On the next date, tell us where you are going. If you find that there is no material, drop it. Because no incriminating material as such has been found.
On the
What is the what is the electronic devices that you have seized? What has come out of that? Khasi and two TMT bars. What has come out of that? So why have a proceeding just for the name of it? Mr. S.A. Learned Counsel, Standing Counsel, GST submits that he be granted time till 27/8/28/28, on which date he shall apprise this court with regard to the conclusions arrived at by the investigating officer basing on the material seized from the premises of the petitioner, based on the material seized from the premises of the petitioner. Also, raised to list this matter again on 29/8/2025 on 1/9/2028, on which date 25, on which date Mr. S.C. Learned Standing Counsel, GST shall apprise this court of the developments taking place in the matter.
Can the 4th of September, Lordship permits, 4th of September?
4th.
Much obliged, Lordship.
4 is Thursday. We'll have it. You are here on 3rd. 3rd on 3rd. Go here. 3 now.
Obliged, Lordship.
And Mr. Kel, please, I don't want to hear that because he's not cooperating. You are not taking the matter. You take the matter forward, come back. Ivan?
Payment of admitted contractual duty.
Why? Why? You have given him a work completion certificate also.
Thereafter, another report of.
Then,
The last phase is the report.
then Ms. M. Das, Learned Counsel for the, heard Mr. P. Bhardwaj, Learned Counsel for the petitioner. Also heard Ms. M. Das, Learned Counsel for the Learned Standing Counsel, PWD, appearing for the respondents. The petitioner in the present proceedings has prayed for a direction upon the respondent authorities for release of his contractual dues amounting to rupees 44,13,894. Full stop. The petitioner in support of his case has placed reliance on the completion certificates as well as reports submitted by the respondent authorities which demonstrate that the work was successfully completed by the petitioner herein. Full stop. Ms. M. Das prays that she be given a last chance to receive instructions and file an affidavit in the matter. In the event the affidavit is not so filed on or before 4/9/2025, this court on the next date of listing shall proceed to finally consider the writ petition basing on the materials available on record. Full stop. The admitted dues of the petitioner not having been released, this court would also consider passing of interim directions, which would be saddled upon the concerned officials who were dealing with the matter. Full stop. Accordingly, registry to list this matter again on affidavit file 09 on 8/9/2025. Thus, we'll now saddle you the officers concerned. Same.
Ready, my lord.
Affidavit is ready. Okay, give it. One affidavit is ready. Why 1 more week? Give me a date. Tomorrow, day after, whenever. Day after we are not here, 18th. File the affidavit on 18th. If it is ready, file it. Next week only 18. 18 is next week. But if you don't file, it will be in trouble. Ms. M. Das, Learned Standing Counsel, PWD submits that the affidavit is ready on behalf of the respondents represented by her is ready and would be filed on or before 28/2025. Registry to list this matter again on 29/8/2025. Inadequate compensation. Go before the reference court.
My lord, in this case, no regarding the land value, my lord, but they violation the provision of the act, my lord.
Fine. That also can be brought within the purview of a reference order.
My lord.
And why have you not filed any affidavit here? Okay, you want this court to consider? Okay, we'll consider.
They have alternative remedy.
She does not want to go.
Will appeal the remedy.
Let the matter remain here for another 5 years. Then we'll pass this order. If the petitioner is not agreed, I am not going to. Yes, when are you filing your affidavits? The Learned Council for appearing for the respondents submit that they be granted for 3 weeks time to file an affidavit in the matter. Prayer accepted, registry to list this matter again after 3 weeks on a date to be fixed by. This will be pending here, madam. You are not going to get anything. You take a disposal, go there, we'll direct the district deputy commissioner to refer it, we'll give a time frame. That's only we can do. Okay, fine. Let's see.
Lordship, here in this matter, we have received instruction, Lordship. We need 2 weeks time to file our affidavit, Lordship.
Ms. Arthur, government advocate, appearing for the respondents number
125.
125 submits that the instructions have been received, complete instructions have been received, and the affidavit on behalf of the said respondents would be filed on or before take your time, tell me. Be comfortable.
It's on 24th of
29 on 29/8/2025. Registry to list this matter again on 8/9/2025. So in the meanwhile, the respondent, the petitioner shall be at liberty to bring on record his rejoinder to the affidavit now undertaken to be filed by the respondent number 125. Also, interim order passed earlier to continue till the next date of listing. The records have come.
By tomorrow.
Okay, Mr. D. Nath, learned government advocate, submits that the affidavit on behalf of the state respondents would be filed on or before 18/8/2025. Registry to list this matter again on
Friday.
26/8/2025. Or you want it earlier? Because I'll have to give him some time to file affidavit also. 20? 27? 22nd?
Second.
Okay, 22/8/2025.
Interim to extend.
Interim to continue till the next date of list.
Give it time, my lord, if they will file a rejoinder.
I've already said.
Not.
Because he's right. This is with regard to supplies to the
Yes, yes.
jails.
Concerned about that.
So 18, affidavit filed, list the matter on 22. In the meanwhile, petitioner at liberty to file a rejoinder.
Fine.
Yes. Yes, I know that. That is why we asked you. 2 p.m. What do you say? Thank you. We'll hear the matter at 2.
Because my lord, they have already constructed. There by February, they will be shipped. So basically, we have no serious objection. That is, yesterday, my lord, I had that's that. Second, please.
At 2. Mr. Chaudhary is around?
Lordship, sir.
I think 13 and 14.
Uh-huh.
My knowledge friend is here.
Huh.
Actually, I have a fixed matter at 2 p.m. at court number 3.
Hmm.
So it may kindly be taken at 3 p.m.
If the court is alive till that time, we'll be here.
We hope so.
Monday, Mr. Chaudhary, I'm sorry, I'm not troubling the office.
Lordship, in this matter,
No instruction. 13 and 14.
Affidavit has been already filed.
So 13, 14.
there was some direction.
Oh, that eviction matter. No, that land, both of you are claiming. Yes. Yes, why this instruction has not come? Huh? Why? When did you write to the Deputy Commissioner? 24/7, and he has not responded till now. Okay, call him. Where is he from? Borpeta. 3 hours. He can come. What is this? Court is passing a requiring. He does not have, he is not responding. What is this attitude? You have issued a letter to him 24/7, and why is he not responding? Get me that information by 2. We'll accommodate, but let me get that information. Why the materials were not sent? The Deputy Commissioner's response, let me know by 2. I don't want him here. No, 2. Call him. 1 hour is there. You have sent a letter to him. Why he has not responded? I just want to know. Forget the information. I just want to know why he has not responded to your communication of 24/7. That much only. We'll pass the order, sir.
Engineer will be there.
Whoever. We'll not pass any adverse orders. We'll only want this. This court required some information, requested you. You took up the matter with the Deputy Commissioner on 24/7. Why he has not responded till now? We want that. The action cannot be held to be bad. But Mr. Ghosh has submitted that they are shifting out of that area. So what do you say, Mr. Gogoi, on that? How long will it take for you to shift?
Because we have a science laboratory there, my lord. That laboratory, my lord, shifting it takes, because you have to construct there, my laboratory, as your lordship is aware, because it cannot be constructed.
But this material having come on record, and it having demonstrated a school to be functioning there, what should we do now? We'll have to follow the rules.
By the rule, my lord, that education rule of 2006.
Either as it may, the school is a recognized school. So if that is functioning there, the decision of the excise authorities, we cannot. It is up to them. We will not say, we will only say whether it's in compliance with the law or not. If the college is shifting out from there and the excise authorities are agreeable, fine. We'll give you a copy of that report. And you make your submission. Mr.
May I get a copy?
Yeah, everybody will get it.
She make after 4-6 weeks, Mali, because they are enjoying the interim order. They are.
No, that is a different thing altogether. We are fixing it in the very short date. You make your submissions thereafter. In terms of the order dated 5/8/2025, Mr. Chutia has, Mr. T.C. Chutia has placed on record an inspection report submitted by the Deputy Secretary, bracketed RPR, bracket over, Assam State School Education Board, with regard to the functioning of the respondent number 6 college at its R.G. Borua Road campus. Also, before a view is taken by this court with regard to the said report, this court would like to furnish a copy thereof to the learned counsel for the contesting parties. Also, Xerox asset Omar. Xerox ko video pai bhai pura. The courtmaster shall furnish a copy of the report, a Xerox copy of the report to the learned counsel for the petitioner, standing counsel, excise department, and the learned counsel for the respondent number 6 during the course of the day. Also, the learned counsel for the parties shall make their submissions on perusal of the said report on the next date of listing. Registry to list this matter again on Kundina Divapari. Good delivery. I'm a power. I got 90. 27/8/2025. The report this court places on record appreciation to Mr. T.C. Chutia and the officer who had done the inspection report on the request of this court. First, the copy of the report is kept on record and marked as X for the purpose of identification. Thank you, Mr. Chutia. এইটো বন্ধ কৰি থৈ দিবা আৰু এটা প্ৰথম পেজৰ কপিটো সবকে দি দিলে। List this matter before any other bench without me.
I need 3 days time to file a amended cost title.
Mr. R. Chakraborty undertakes to file the amended cost title on or by tomorrow, that is 14/8/2025. Registry to list this matter again after 2 weeks on a date to effect.
All right.
If you don't file it, gone.
I'll file.
For which time I granted the filing reply in this case.
Why?
The nature of the prayer and the petition quite compensation. That will require exercise of giving evidence who is entitled to what. I'm questioning the maintenance limits. Because we file affidavit. It's to be a occupant of Tozi land. The prayer is to pay compensation of 20 lakhs.
Is there an interim order here?
That High Court order is as per High Court.
Your case is that there was an order of this court which was violated by them in proceeding to make the demolitions. Their stand is by the time they got the order, half the thing was already done. Then they stopped. Demonstrate that you had given this copy to them. You said you had gone to the house of the Deputy Commissioner. His security guard was given the copy, right? And we waited till the security guard came out from inside. But where is the proof that this was given, this was done?
No, I have also, yes, WP message or SMS also given to them. And in the spot also we have.
Where? No, where is it on record? In the writ petition. In the writ petition. Some MLA had given MLA had forwarded that. And that was after the demolition exercise was completed. Yes, in the evening,
No, really. Demolition, they have.
5:07 PM. Page 146, top portion. So just show me that the deputy commissioner had knowledge and thereafter still went ahead with the demolition exercise.
Earlier date, Your Lordship, it is. The spot also, they have very bad, Your Lordship. 5:50 AM, Your Lordship. It's 47, 147. Spot also, when they have gone for eviction, they also provided the certificate about the refusal.
This is 5:55 AM of which day?
The day of permission, Your Lordship, morning, on 10.
Array. 9. Your statement here.
Is Your Lordship 2 orders, 9, 10 and 10, Your Lordship. 9/1 for 2024 also our court's order is there. 124 orders we have communicated. 10 for also, Your Lordship, 10/1 also there.
Assuming, madam. That round was somebody different person.
Not this petitioner. Sure.
Page number 40, madam, to order. Safa Begum and 4 others. Safa Begum.
No, there are 2 orders.
Oh, no.
There are 2 orders and in one Safa Begum is there. Page 128.
All are repeating.
Okay.
Information received, my lord, that eviction.
Who WhatsApp from whom?
No. Eviction was held on 10.
He got it on 9/1. So when was the eviction conducted?
10/1.
10/1. Where do I get that?
10/1, Your Lordship, court's order also you can find.
No. Where do I forget the court's order? Where do I get the date that the eviction was done on 10/1? Because the categorical stand at 152 is that he put it on a hold.
No.
Yes, Mr. Islam.
Your Lordship, end this.
No, you satisfy me from the petition. Reply will come.
Page 18, Your Lordship. Para 18, Your Lordship. Illegal eviction, but there's happened on next day, next day, illegal eviction, that is on 11/1. Admission of all parties is hanged on notice. Election, next day, Your Lordship. 10/1, it was dictated, and next day, Your Lordship. On 10/1, repetition was listed. Before this could also intimate the court also, they have gone for eviction. The court also inform the government advocate to stop the eviction.
Yes, para 8. 153. Last 4 lines. On 10 and 11, it was done. Eviction was carried out. So there is a violation of this court's orders. Huh? No, your affidavit. Okay. Come to para 8. Whose affidavit is this? Oh, it's yours. Yours, revenue. What is your stand in with regard to para 8? Okay, fine. Para 8, Ms. Das, what is your stand? No comments. Mr. S. Islam, Learned Counsel for the petitioner, submits that he be granted time till 29/8/2025 to bring on record the rejoinder to the affidavits filed by the respondents. Also, prayer accepted, registry to list this matter again on 3/9/2025. No further adjournment shall be granted to the petitioner for filing of the said rejoinder.
Non-payment of contractual bill.
Non-payment of?
The total estimate was around 7 crore lordship. Initially, he was paid in the first installment about this is 1 crore lordship. Recently, lordship on 7th of May 2020. In the process of paying the.
No, that you are not doing any charity, Mr. Naik. You're not doing any charity. He did work. You are admitted to that. Why the delay? This court required it to be paid within a period of
Period is not forthwith.
forthwith means immediately. So you had no breathing space also. You have not filed any application for extension of time. This is contempt. You have not filed. Then, so contempt is already made out. No, there has to be a sense prevailing somewhere. So, what do we do? Be that as it may. And we have passed now 3 years. That makes it more serious. Notices were issued. You have not taken up that point immediately, have you? Forget it. Forget it. He is now before us. We'll have to interpret it only, not neither yours nor his, what is there in the record. I can't go beyond that. So tell me by when you can make this payment. So take your time. But I want the payment made. That's all.
Been instructed to me 4.5 crore is paid.
Of whom? Paid to him. So
I have to take that specific instruction. Of paying 50 lakh.
you are not disputing that amount, Mr. Then how can you?
Lordship grants me 1 week time or.
No, I can grant you time to tell me when you are paying. Mr. Pinak, Learned Counsel appearing for the respondents, prays that the matter be taken up on 29/8/2025, on which date he shall apprise this court as to the time period within which the dues of the petitioner shall be cleared. Okay, 19. Done?
They have approached this court, my lord, then my lord order was passed, but they did not pay the whole amount. Again, they have miscalculated. Again,
Madam, the service is not complete.
Service, my lord, that government of Assam has sanctioned the amount later on, And my
The
lord, both writing
respondent, the
separate
notice
letters.
is not served upon the respondent
Yeah.
number.
So my lord, again we send my lord, I don't think, my lord, so my lord, may I request your
Draw up
lordship,
contempt.
my lord, that the notice will be served through my lord Assistant Solicitor General.
No, 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 that will
It's
not.
Government of India. Two steps were taken, but
Wait, I'm not asking you to take steps.
yes.
Seen the office note dated 5/8/2025, which reflects that neither the AD card nor unserved notice were received back from the respondent number 3. Full stop. Further, it says that the process server's report with regard to the steps taken for service of notice upon the respondent number 3 has also not been received. Also, registry to require the concern registry to place this matter before the Laujima court for further examination and a report. So, the matter be listed after 2 weeks on a date to be fixed by the registry. Let the Laujima court take it because usual process also it's gone. So they'll have that process server's report.
Two steps taken, my lord.
Don't worry, we are not asking you to take steps.
Government of Assam has written 5 letters to them.
We'll see.
In spite of that, they did not respond to them, my lord.
Madam Shikha, let us
Can
see what
time
happens. Let us see what happens. If the notice is served, I can draw up contempt. There is no problem.
Alright.
Same thing. 58 also same, ma'am. Same order. Right. 57, 58, same order.
Alright.
May I please, Your Lord?
What is the error, Mr. Das?
Lordship, the relevant portion of the order is in page.
But this is an order of
Yes.
2022.
Yes, Lordship.
Why this delay? What is the explanation for the delay?
Lordship, this because of some official formality.
No.
And-
Where is your explanation for delay in the review? There is no explanation. A review cannot be filed as per the sweet will. This review petition was filed only on 3/6/2025. Order is of 27/9/2022. Where is that explanation? Because if there is anything, you knew it at that point of time. You have not come up. And if something you have known thereafter, will not, because you have not said anything in the review petition to that effect.
Lordship, at that moment of time.
Huh?
At that moment of time, yes, we have not said, Lordship.
Then why should I review? What is the error? There is no error. And these actions were all to be completed within 2 months or 3 months within that after passing of the order. You were well aware, you have done nothing. You were sitting over the matter.
No, Lord.
And after 3 years, you wake up and come. Will not accept this.
Same order benches has passed, Lordship.
Huh?
The review, this is not the fresh, means these are the fresh reviews, but other reviews are there because we have filed 125 reviews and other Honorable Justice Suman Shyam had passed the orders in that review orders, Lordship. As well as it has come to other coordinate bench of Honorable Justice Devasis Burwa also. Lordship, coordinate bench has passed these orders, Lordship. Me.
Dismissed. Rightly so. We will follow the same order.
Yes.
Mr. Aramdas, learned, heard Mr. Aramdas, learned counsel for the petition. Also, the present review application has been filed, praying for review of the order dated 27/9/2022, passed by a coordinate bench of this court in WPC number 4734/2021. What is the repetition number involved here? Ms. Deka, just find out and give it a list. In WPC number so and so. So and so, full stop. Similar review petitions assailing the common judgment and order dated 27/9/2022, passed in WPC number 7833/2018 and other analogous matters, was also a subject matter of challenge in review petition number 137 of 2025. The coordinate bench of this court, on consideration of the matter, was pleased to reject the said to dismiss the said review petitions. Also, the conclusions drawn by the coordinate bench in the order dated 37/2025, passed in review petition number so and 137/2025, being relevant, is extracted here and below. Para 5 or plus. Para 7 only. So, this court is in respectful agreement with the conclusions reached by the coordinate bench of this court in the judgment and order dated 37/2025 in review petition number 137/2025. Accordingly, in view of the same, the present review petition is also held to be devoid of any merit, and the same is accordingly dismissed. However, there would be no order as to cause. Same order over tomorrow. Item number 59, 60, 61, 62, 64. Same order. Thank you. Yeah. Yeah, 66 time being
Time being 3.
Follow up Bishop. Maybe Ms. Gayan is still on legs. Yes, Ms. Gayan, what have you received?
I have already conveyed that give until filing of it.
Sorry, when we have no jurisdiction, we will not do anything. No. That we cannot. You withdraw it, I'll give you liberty. Before the appropriate form. No issue. Ms. A. Gayan, learned CGC, on instructions, submit that she be permitted to withdraw the present writ petition, however, with liberty to approach the appropriate forum for assailing the order impugned in the present proceedings. Prayer is not objected to by the learned counsel for the respondent number, sole respondent. What is sole respondent?
There are two respondents.
Respondent number 1. Also, in view of the above submissions of Ms. M.S. A. Gayan, learned CGSE, the present writ petition stands dismissed on withdrawal. However, liberty is reserved to the petitioners to approach the appropriate forum for assailing the order dated 15/3/2024 passed by the Micro and Small Enterprises. Page 10, huh? My Enterprises Facilitation Council, Yadari, Bhuvanagiri region, Yadari, Bhuvanagiri, Telangana state. Mo jikhini page 10 of jikhini mane dag dit hoicho. In case number TS/S/YBR/00021, Tinta 021. Also, I8 likha, in view of the order passed today in WPC number 1786/2025, no further order is called for to be passed in the present interlocutory application, and accordingly the interlocutory application stands closed. A agor order to likhiba ta khatam korar agot dismiss korar pisot interim order passed while this order dated 4/4/2025 stands vacated. You take up immediately, otherwise the clock is running very fast. It's public money after all. Yes. Yes, Mr. Borua. What happened? That is what I know.
Actually,
This could have been done without that, with this court requiring to tell all those things.
no. It was actually they have sent already. But some miscommunication with.
Oh. So de-reservation still now not done. Yes. VGL land. But you have already issued communications way back. Governor is pleased to de-reserve the. Yes, Mr. Chaudhary. You can come to page 20. What is the effect of this? This is what I wanted to know. Page 20. Okay. I'm giving you a copy of this. Mr. S.R. Borua, Learned Counsel for the petitioner, in terms of the directions passed by this court-wide order dated 21/7/2025, has placed on record the instructions received by him from the Office of the District Commissioner, Borpeta. Also, Mr. Borua shall furnish a copy thereof to the Learned Counsel for the petitioners in the above noted two writ petitions. Also, the learned counsels appearing for the petitioners are at liberty to make their submissions after perusal of the stand as disclosed in the instructions furnished by Mr. S.R. Borua, Government Advocate today. The registry to list this matter again on 3rd or 8th, whenever it's convenient to you. September. Second you?
8th of September.
8 and 9, 2025. Mr. Borua, you'd give it, then keep it back here. A copy of the instructions furnished by Mr. Borua is kept on record and marked as X for the purpose of identification. You just give him a printed copy. Give him a printed copy. I'm not saying that Mr. Chaudhary is not tech savvy. He's very highly tech savvy, but it'll be very convenient for him if a book, hard copy is given. Right?
Whatever way.
See, that has got to him. But Mr. Chaudhary, just a decision to de-reserve will not be enough. There has to be an actual notification of de-reservation. There is a process for that. If that process is not followed, just for what is there, if that process is not followed, today after Jaspal saying you cannot follow that process, what would happen then? as an officer of the court, what would happen then? These people admittedly have, there was a right recognized in them way back in 1967. So they cannot be held to be encroachers or something like that. But thing has to be done lawfully. So can this court pass a direction? Say, okay, VGR land not used, there they may not be eligible. But can this court under the land policy of the state also direct the state to look into the aspect whether you can be rehabilitated? Kindly look into that.
The lawsuit has to consider. Things have to be considered.
Consider, because I request some assistance on that. Mr. Bachchaji, I am not on that. 1967, who are these petitioners? You had taken a decision to de-reserve. Fine. But that decision also would go to reveal that you have recognized their right for that settlement at that point of time. If that be so, that has to be taken to a logical conclusion. After this such a long period of time, not in VGR land, but whether some other land you can rehabilitate them. That much only. And they are breaking their heads in between, let them break. Whoever wants. But we are concerned with the people you have identified, not beyond that. Whoever is there, that for them to decide between them what proceeding they do. But 131 families, 39 families have been identified. Those families, what will you propose? Get your instructions also on that.
The inspection in all with the matter.
What is your instruction? They have. Yes, give me. That is why Mondal had not brought on record any materials about their earlier land. Yes, Mr. Mondal, you are a joint pattadar. 2 bigha land you have, your family has 2 bigha, 2 katha, 10 losa at village Boizar Alga, Atani Revenue Circle.
I will not have those.
Huh?
Can I not have those too?
You have it, but why have you not disclosed your land particulars in the present writ petition? You were saying to be a resident of Mayasor in Bilasipara. Where are the particulars of that land that you had under your possession? And you came here admittedly only in 1998. So your family from 1951 till 1998 were there in that land. Where is the particulars of that land? Nothing is here. Only thing you have disclosed is after 98. How can we hold that you are a bona fide? And now with the further thing that you have other land. You have done your part. Thank you for that.
If that be so, my lord, let them file.
Get it. We are not interested in filing.
will
We are
file-
not. I'll only dismiss this case with this para 2 and 3. Does not disclose. Very casually done. NRC 1951, very good. 2019, that is in Dhubri, where you have shifted in 98. So from 1951 to 1998, that you had land which was eroded. Where is the proof?
That document, my lord, I will, my lord, file by additional evidence.
No, this has to be here. There is no mention here that you had land.
Now, in that case, my lord, if they file affidavit, my lord, we can reply to that, my lord. Otherwise, my lord,
Is there an interim direction here?
no interim direction.
No interim order.
No interim order.
Mr. Borua, can you convert this into an affidavit? Do it. In terms of the directions passed by this court-wide order dated 4/8/2025, Mr. S.R. Borua, Learned Counsel, Learned Government Advocate, has placed on record the instructions received by him. First of all, a perusal of the said instructions would go to reveal that the petitioners in the above noted writ petitions have a landed property in their respective names and were, in addition to that, occupying government land from wherein they were being sought to be evicted. Also, in the event the petitioners have patta land in their name, either as a pattadar or a co-pattadar, the petitioners herein cannot be deemed to be landless persons and accordingly would not be entitled to any further settlement of land under the land policy in vogue in the state. Also, Mr. S.R. Borua shall bring on record the said stand by way of filing an affidavit in the above noted writ petitions so as to facilitate the petitioners to counter the same. Also, registry to list this matter again on, full stop. The said affidavit be filed on or before 1/9/2025. Registry to list this matter again on, you file it on 28/8/2025. Registry to list this matter again on 8/9/2025. Full stop. On filing of the affidavit by the respondents, the petitioner petitioner shall file. Liberty is granted to the petitioner to bring on record a rejoinder thereto, if so advised, on or before 5/9/2025. Registry to list this matter again on 10/9/2025. I'm giving this back to you. Mr. Borua, this is the only things we want. What is the high headache here? Huh? Just that much you ask them, get it, we'll pass orders. Right? Please, there is no rocket science here. We just want the clarification on facts only. Give them a letter, make a phone call, let it get, because it's helpful for you, it's helpful for the petitioner, helpful for me.
29.
Yes. Yes. Talent. Whether it falls within the boundary of the Popitora forest, reserve forest. That is not clear. That is what is to be clear. That's all. Simple.
Because there is a office of the.
Fine. It's not only the, see, in law, it's not only a private person who can be an encroacher. The government officers, departments can also be encroachers, maybe unknowingly. That is only what we want to know, whether the land of the petitioner falls within the reserve forest or outside. If it is within the reserve forest, what is the proof for that? That's all. Tell me, I'll record it and I'll pass orders. Then either the land has to be returned to him or he will have to be compensated. Patta cancellation today will not work out once the damage has already been done. I don't understand why this limited instruction, whether the land falls within the forest area or outside. That's the only thing. I've seen your affidavit. We are not very If that land falls within the forest area, you need not cancel. I will cancel it. I'll say, Mr. Bhattakur, go. You don't have a case.
One aspect is also there, even if it is falls within forest area. By an earlier order, your lordship, on earlier pointed out whether your lordship, when this notification was issued, your lordship, proclamation was issued, whether that was there to be within the proclamation or not, your lordship.
No, that is what I'm asking, whether the notification that has been issued, defining the boundary of the, it has to be a defined boundary, whether your land falls inside or outside.
And whether I have got opportunity to raise my claims or not.
No, your patta was issued only in 19.
Oh, your lordship, I have an actionia patta, your lordship, prior to that. From
Fine,
50
that exonia will it give you a right?
Yes, your lordship, I have the judgment, your lordship, of this honorable court.
Then it will be a case of accusation.
Until and unless, yes, process of acquisition.
Acquisition.
Yes.
So maybe you will be entitled to not the land value, but the zirat.
Lordship.
You won't be entitled to a land value, you will be entitled to a zirat.
Year land, your lordship, 1 yearly patta, your lordship.
Annual
Until
patta.
and unless, your lordship, it is
Cancel.
revoked, then your lordship.
Right.
it is transferred
I think there was one judgment, yes, wherein they said that you have a land right to the.
Suman Sam, your lordship.
There is another judgment also which was that you don't have any right over the land, you may have a right over the zirat.
So far as government khas land is concerned, I have only Jirat, your lordship, I can get. But when it's a kind of your lordship settlement.
Temporary settlement.
Yes, sir. Yes, sir.
So when are you getting this instruction? Whether it's, yes, whether it's within the boundary of the. Your possession, Mr. Bhattakur, is inconsequential. Whether the land of the petitioner falls within the Popitora Reserve Forest or not, that much only I want to know. But, Mr. Bhattakur, you don't get my point, or you are feigning. You're not that. You're not what you are trying to project yourself now. You are too intelligent to that. You have understood, but why are you not answering me correctly? Whether the property falls within reserve forest or outside the reserve forest. That much only I want. Your house is there, not there, that is inconsequential. Even if it is outside the forest area, you can still encroach on it. Can't you? You can. But what is the answer to this question? That was already directed.
When verification done, your lordship.
Then it came in your favor.
Original notification will clear everything.
Where is that notification? That was
But
directed to be
time was
produced
granted to
on
them.
10/6/2025. This court.
We have the
That not.
Okay. Mr. I. Bhattakur and Mr. N. Goswami. Learned. I. Bhattakur, learned standing counsel. Forest Department. Mr. N. Goswami, learned government advocate. What is the affidavit of the Deputy Commissioner say? Oh, that is only to the extent that he is going to cancel your patta.
Patta, and your lordship also says your lordship. As per the Cheetah of year 6970, a plot of land measuring 7 was settled under annual patta in the name of Sri Madam.
In pursuance to the orders passed by this court, wide order dated 10/6/2025, pursuant to the directions passed by this court, wide order dated 10/6/2025. The District Commissioner Moringo has filed an affidavit in the matter. Also, in the said affidavit, it has been contended that the land of the petitioner is in possession of the Forest Department since 1971. Also, however, the said affidavit does not disclose as to whether the plot of land of the petitioner, in question in the present proceedings, falls within the notified area of the Popitora Wildlife Sanctuary. Full stop. In view of the above position, Mr. I. Thakur, Learned Standing Counsel, Forest Department, and Mr. N. Goswami, Learned Government Advocate, shall on the next date of listing clarify as to whether the plot of land of the petitioner involved in the present proceeding falls within the notified boundary of the Popitora Reserve, Wildlife Sanctuary. Also, the said instructions be placed on record on the next date of listing. Registry to list this matter again on 3/9/2025. Then we will decide. If you find that this is there, already there in the Popitora, then we'll see what can be done. But if it is outside, he is clean. We'll have to leave him. And the encroachment, if any, you will have to remove or acquire it from him. That much only.
Deeply obliged.
54.
Yes.
It made a query regarding
Membership.
membership.
A
I have
cooperative
the-
societies act.
The document, Lordship, only, the annexure. Case 12 annexure A1, the document regarding
This is of 96. That you continued to be a member thereafter. Where is that material?
yes, Lordship, I am referring para 5 of my writ petition, page 6, para 5.
Para 5, page 6. Okay.
Reading it, Lordship.
Para 5, page.
Para 5, page 6. Petitioner stated that the petitioner and some other members of the society have raised objection to such in an arbitrary nature.
But where is that? Where is that material to counter the conclusion at page 15 last line? That he
Yes,
has
that
written
Lord-
this without any basis. Nothing.
Regarding the documents, nothing has been,
Then,
but the petitioner has set the entire order in the appeal itself.
you withdraw this, pursue your appeal. Otherwise, if you have to come in, everything will go.
Lordship, but
Your Lordship, I have received.
Review dismissed.
By the Joint Secretary to Kamal Chaudhary and Mishra. Thousand 24.
what is the name of your Kamal Chaudhary? But Mr. Here, a reference to 92, he also involves a past member. He is a past member. So what is the whole thing is perverse. The conclusion is perverse, that means. The grievance can be considered. Huh? 92B. Member, past member, or person.
Per member.
Huh? Kamal Chaudhary. Avinash Mishra, we got it. But Kamal Chaudhary, he has a certificate here.
Kindly see, my lord. Page 15, there is no, my lord, in connection to this,
Share account.
my lord. He is not the secretary.
Have you filed a criminal case when you received the writ petition? Copy of the writ petition. Then?
Debit card. Page 13, my lord. Page 13, my lord.
Where is
Clearly
your plea in the affidavit? Have you filed an affidavit here? Why? Why? Not filed. You appeared last month only. I think we'll have to interfere with this order. He has brought something you have not disputed. Why should we wait? And why was this certificate not produced before the register?
That's as per instruction of the.
But this is last line of page 15. And you have not dealt with that.
Yes.
You have not dealt with
But,
that.
but when he appeared, so asking for the documents,
So where is your statement to that effect?
that statement is not there. Already I have stated, Lordship.
So, when there is categorical finding of a fact by a body competent and this certificate is disputed, we'll have to follow that. Heard, Mr.
G. Kakoti.
G.
Kakoti.
Kakoti, Learned Counsel for the petitioner. Also heard Mr. G. Bodle, Learned Standing Counsel, Corporation Department, appearing for the respondents number 2 and 3. Mr. You are appearing for all. Item. What was the complaint filed by respondent number 6 before the register? Hmm? Hmm.
The wife and husband.
Why do you say that only one member can become a member of the cooperative society? Which is the provision? Also heard Mr. G. Alam, learned counsel appearing for the respondents number 4, 5, and 6. Also, Mr. G. Budley has placed on record order passed by the passed in the review application preferred by the petitioner under section 111 against the order of the Register of Cooperative Societies dated 28/9/2023. Also, the Register of Cooperative Societies as well as in the order dated order passed by the reviewing authority. The complaint raised by the petition, one of the grounds for rejecting the complaint raised by the petitioner was that he was not a member of the respondent number 4 cooperative society. Full stop. The learned counsel for the petitioner by referring to annexure A1 receipt submits that the same is the same is the receipt issued to him while he had taken a share in the respondent number 4 cooperative society. However, the said position is disputed by Mr. G. Alam, learned counsel for the respondents number 4, 5, and 6, and he goes to contend that the said certificate is a forged one, not issued by the authorities of the cooperative respondent number 4 cooperative society. Mr. Alam has further submitted that the petitioner was never a member of the cooperative society. Also, in view of the above position, in view of the above submissions, the same not having been so made by way of filing an affidavit, an opportunity is granted to the respondents number 4, 5, and 6 to file an affidavit in the matter on or before 21/8/2025. Registrate to list this matter again on 1/9/2025 for further consideration. A copy of the communication dated 3/6/2024 furnished by Mr. G. Budley is kept on record and marked as X. Also, Mr. G. Budley is required to furnish a copy of the said communication to the learned counsel for the petitioner for his information. Last thing. Yes.
Order, my lord, of the learned tribunal, my lord.
I forgot. Where is it?
On the, my lord, page number 18, my lord.
80.
18, my lord.
18.
Last 4 line, my lord. In fact, 5 line, my lord. C, my lord, C also stated that after grade 1 as turner and machinist, they need promotion to senior technician, master craftsman. And Mr. Ascenda, senior technician MCM, retired on 31/12/2005, who was machinist grade.
Same like the. Yes.
Respect, my lord. I hope my learned can change their line of. Good day, your lordship.
Okay, fine. This is something which is there on the records. That that SN Das, that's the vacancy we are saying. Your case is that is what we also went to an examination where the turner, machinist are two different trades. HCM or the what you call that senior technician, master craftsman is in one line or in two lines. Your case was that he was a turner and this post is in machinist. But now this is seemed to be a machinist. This is a recording of fact.
No, kindly see page 26.
20.
Where it is a statement by the witness of the management matter. Now page 26. Their record, it is their annexure, it is their document. Grade 1, my lord. And by the witness of the is why, my lord. How your lordship kindly see the page again 18, my lord.
Page 18.
My lord. Of course, it is a 17, my lord. In fact, my lord. I am reading, my lord, 5-6 line, my lord, from the bottom.
From bottom.
No, my lord. First paragraph. He also added.
Yes.
Added that when it is a in the cross examination of the WW. He also added that when the vacancy had arisen for the post of master craftsman in the turner grade, that should be filled up by the senior man, namely the workman Subhash Bonik, but it was not done by the management. Rather, H.G. Rava, machinist, grade 1 was promoted illegally as master craftsman by maintaining inter-se seniority. It is also stated that at the time of retirement SN Das, only one post of master craftsman was vacant in turner grade.
Got it. Anything more, Mr.
And there is no post of craftsman in the machine.
Okay. Anything more?
My lord, now lordship may kindly come to the last para of this judgment, my lord. What the finding, my lord. Para 19, my lord, at page 23, my lord. Page 23, my lord.
Page?
Page 23, my lord.
23.
Para 19, my lord. From my above discussion and have heard both sides and taking into consideration the decision of the Honorable Supreme Court as mentioned above, can safely be held that the management has failed to implement the procedure for restructuring of the post in the event of redeployment of the worker in carriage and organ department. Were given the status of supernumerary post holder by creating special supernumerary posts for them, while the management is ignoring this restructuring formula and other guideline issued by the Railway Board from time to time, and discuss about promoted the man from machinist grade to the post of master craftsman senior technician. Such as act was done by management in violation of the provision of Article 14 of the Constitution as well as the principle of natural justice as well. As the rules and guidelines of the Railway Board causing grave irregularities and injustice to the workmen, as such, I am of the opinion they should have been promoted master craftsman with effect from so and so, my lord. Now, my lord, why, my lord? They were directed, my lord, we have not given them restructuring benefit. My lord, it is not said, my lord, that the H.G. Rava was wrongly promoted. Otherwise, my lord, the finding would have been, my lord, that H.G. Rava should not get this post. It is.
Can you say that?
Again changing that. That is why I am with all.
Can you say that now? Mr. Gusar? How can you say that now?
Now, my lord, the last.
Where is
second matter-
the statement of this lady? The lady who had deposed
Internal page 7
my lord, page-
of the judgment.
internal.
It is in the record also, I have seen. Para 8 of the judgment.
Record to some.
It is para 8 of the judgment.
Swapna Chakraborty. Swapna Chakraborty.
Sapna, sir.
Yes, anything more? Anything more?
The tribunal has considered, my lord, restructuring, my lord, and my lord passed the judgment on the basis of restructuring. And my lord, the appointment of H.G. Rabha was never, my lord, questioned, my lord.
Look.
My lord, I'll go to my lord, page 22, my lord.
Got it.
Page 22, does it clear from the above discussion, the management that has not implemented the procedure for restructuring?
You say that this will have got no application here because they were already retrenched and then adjusted. Okay, give me a small note. I've lost this track slightly. Give me a small note, both of you. When? Week's time? Third day, Learning Council for the parties. Also, hearing remains inconclusive. Petitioners submit that they would file their respective written arguments on the next date of listing. Registry to list this matter again on first you got it here. 2/9/2025. 4/9? 4/9/2025 for further hearing. Just give me a small.